Notice, have you given notice? Objection, what is the urgency? Restoration application. So under the heading application, the writ petition is to be restored first. So under the heading application, you keep on watch on the list. It will.
Milord, that 2017 hearing matter, Milord, I mentioned on the last Thursday also upon notice. Notice is there, Milord. Mentioning was allowed, but it is not as come on the list. Mr. Ayan Banerjee is appearing on the other side. I have also intimated him.
On the date, objection matter will be placed at the top of the list on the
Inclusion, Milord.
inclusion. Inclusion in the daily supplementary list. What is the urgency? So urgency. Then your matter is to be given precedent over the others.
It is at final hearing stage. Another criminal proceeding is also there, which is at the verge of ending. That's why, Milord, I am trying to hold up this petition before the honorable court as early as possible, so that an order being passed.
In connection with the writ petition, one criminal motion has been filed.
No. It is a separate proceeding. The thing is, Milord, I have challenged the illegal termination of an employee. And Milord, it is at the final hearing stage. Affidavits have also been.
Oh, okay, wait, many matters. I have 700 matters I have already included. Yes. Wait for some time, yes.
My lord, it was already allowed.
Okay, if allowed, it would be included. Wait, yes.
Milord, hearing matter, Milord, for inclusion I am mentioning, Milord, there is extreme urgency. I just indicate what the urgency is. Milord, this matter pertains to all the state government employees. Milord, they are great pay where Milord enhanced, Milord, giving a retrospective effect. But Milord, the way Milord great pay has been enhanced, Milord, that has created Milord a disparity amongst Milord all the employees. Now Milord, juniors are getting more than what the seniors are getting. Milord, which is why Milord, the writ petition is filed. Milord, the state government has used an opposition where they have accepted, yes, there is a disparity. So Milord, the matter is otherwise very short. Milord, there is a statewide Milord.
Okay, it would be included.
Milord, in the next. Milord, may it appear in any day in the next week, Milord.
Next
week. Indicates a date. Milord, at least once, Milord, if the matter is taken up, I can at least, Milord, stay, Milord, this Milord clients. Milord, they are banging their heads on the wall. And Milord, every time, Milord, I am being, Milord, my Lord can understand. Any day, my Lord, the matter is taken up at least once, my Lord, I can place my case for 5 minutes. At least I can rest in peace. There lies the difficulty. Rest in peace মানে মরে যাওয়ার কথা বলছি।
Okay. Okay, it would be under the heading for hearing. And for hearing বলে লিখে দিন তারপরে একটা
may a date be indicated so that I can communicate to my clients?
Date cannot be
any day, Milord.
আচ্ছা এটা আপনি একটু আগের দিকে হেয়ারিং এর আগের দিকে দিয়ে দেবেন তো যেদিন হেয়ারিং ম্যাটার নেবো সেই দিন।
So grateful to your lordship.
Yes.
May I be permitted to mention for my lord upgradation, my lord, of my lord 442 of your lordship monthly combined list, my lord. My lord, earlier I mentioned this matter be your lordship on Thursday, my lord, and your lordship directed me to mention today, my lord, after the publication of the monthly list, my lord. My lord, the agency is, my lord, the petitioner is a candidate of state, my lord, 2014. My lord, he has passed the, my lord, written test. Thereafter, he was called for viva and interview. He cleared the, my lord, viva, and thereafter, my lord, he was cancelled. He was cancelled, my lord. Appointment was cancelled, but without any giving any justifiable grounds, my lord. My lord, kindly for your lordship, including the upgraded matters, my lord. My lord, it's just 23 matters, my lord.
Oh, good.
My lord, may I be permitted to inclusion in the list?
Why? What is the urgency?
The urgency, my lord, is the petitioner filed a writ petition being number 2169 of 2018 for termination of your petitioner without giving a notice from the post of BLO by the.
Oh, wait for some time. Wait for some time.
Yesterday, some confusion. This has not come. Can you appear on the top of the list? I couldn't know. Mr. Devoprabhu Shara appeared a lot. Can it be tomorrow? Tomorrow then. Okay.
Hmm. So come tomorrow. Hmm? Tomorrow 10:30. Okay, tomorrow at 10:30. 10:30 as a 10:30. কেন আসেনি এটা বুঝতে পারি তো কোর্টে দাঁড়িয়ে যখন whether it is in the list. Okay, upgraded matter, upgrade. Actually, all matter will be suppled, resuppled again. And one day upgraded matter, one day returnable matter, one day parted matter, and one day hearing lot 1, one day lot 2. You wait, your matter will be touched. Don't worry. Entire list would be touched. Get yourself ready and then your matter.
My lord, similar prayer with that recruitment process, my lord. Let it be up.
Same matter.
Prayer, my lord. Yes, same type of matter, my lord.
Same type of matter and same matter totally.
Similar type with regard to recruitment process,
If
my lord.
it's same, there was no requirement to use the word type.
Similar, my lord. Similar matter with regard to recruitment process, my lord. My lord, let it be upgraded, my lord.
No, similar type.
Similar matter, my lord.
What is your urgency? You tell. No similar, you tell what is the urgency.
My lord, it is with regard to the recruitment process, my lord. There, my lord, the has been rejected on medical grounds, but there is no medical grounds which is there, my lord. On medical grounds, the candidature has been rejected, my lord. Then I got tested, my lord. There is no medical grounds, my lord. This is my lord.
Your matter is appearing in the list.
My lord, yes, my lord. Item 689, my lord. No, it's not in the list, my lord. I'm praying for inclusion there.
So, wait for some time. Wait the.
My lord, at least let it be included.
Kind leave to mention a matter for extension of interim order. But the interim order was that, my lord, the bank will not take any steps with regard to the, my lord, asset of the petitioner. My lord, it was there till 30th of June. We have filed this application within time, my lord, and it's a pending matter.
Whether it is in the list?
Yes, it is there in the list as item number 280 of the monthly list. But can it appear as the extension of interim order held so that
Extension of interim order.
I have put in the other side on notice, my lord.
Okay.
Grateful.
Huh? ও সিনিয়র সিটিজেন দিন উনি সিনিয়র সিটিজেন বলে লিখে রেখে দেবেন আপডেট করে দিন কামিং টু ইউ
May I be permitted?
From Justice Prosenjit Biswas.
you are from back row. Okay, I am taking. Yes.
Praying for inclusion of a hearing matter. The petitioners are workshop instructors and laboratory assistants in various polytechnic colleges. By various government orders, they have been considered to be a contractual employee, but the benefits given to other contractual employees are not being extended to them. Most of them are about to retire in August or September of this year, my lord. That is the urgency. They'll be without anything if they retire.
Okay, yeah, inclusion or in the list.
Inclusion in the list, my lord, not appearing in the list. Pleadings are complete, my lord.
For hearing.
Okay, deeply obliged, my lord.
My lord, my matter is for upgradation. Petitioner is the old aged person, my lord, above 70 years of age, my lord. The respondents.
Or is a person come in my court. So I am to categorize some matter as senior citizen matter.
My lord, the
Yes, give the SIP,
for
take senior citizen.
senior citizen. Grateful.
So Group 9 matter, my lord, 2019. This matter regarding illegal encroachment on the government land, my lord. There is encroachment on the national highway. That is my completely obstructing my ingress and egress, my lord. It is, my lord, so difficulties, my lord. My ingress egress is completely, my lord, encroached.
So what, you
Sir.
approach the assistant
That I
engineer?
approach, they are not taking any steps. That's so why, my lord. It is in motion, my lord. I'll take it in the motion.
It is motion.
Motion. Right, inclusion in the motion. On
I
application.
have copies. A motion লিখে রেখে দিন, হ্যাঁ?
Application, my lord. Application for restoration, my lord.
Yes.
Lord, may I kindly be permitted to mention a matter for inclusion, my lord? My lord, this matter, the petitioner was dissatisfied with the selection process of 2020, my lord. He is suffering since 2020, my lord.
Okay, wait for some time.
Lord, kindly up.
Many person participated in this election.
Inclusion, my lord, 2016, my lord, opposition.
What you are doing for 9 years?
Yes, my lord, 2019, my lord, he already, my lord, retired, my lord. Senior
You wait for some time, yes.
My lord, I am mentioning one matter, the retired employee of teacher and teacher. My lord, in terms of the safety commission, implementation of safety commission, coordinated bench already passed the order.
Okay, can be given retrospectively.
My lord,
Wait, benefit, such benefit can be given retrospectively, don't worry.
Is appearing in the matter. Mr. Montana has requested, it's not much of it will be requested your lordship, can it be kept to the level 30? Today is be appearing online. Urgently travel today. But this matter is on the list of the E, but Mr. Montana had mentioned that it be kept on the 10th. And matters earlier,
Okay, if it is not today, on any day, it would be taken up.
my lord, fine.
That's all that he
No, how?
Please,
A very innocent mentioning, my lord, for correction. My lord, day before yesterday, lordship has been pleased to deliver a judgment of refugee, my lord. But the direction has gone to a wrong person. I stated that it has to be district rehabilitation officer. Your lordship also agreed, but this judgment has gone to a post
Commissioner.
which is no more in existence.
Okay, yeah. To be mentioned. Under the heading to be mentioned.
From urgent determination of justice, Proceedings Bissas. Second, first message, sir. My lord,
When it will expire? Tomorrow. It will be tomorrow under the heading extension of interim order.
my lord, I shall keep a part of the press notice and shall.
Yes.
My lord, may I be permitted to mention a matter for inclusion? My lord, I am a scientist who was unlawfully terminated by the body IJIRA. My lord, after that, the last order that was passed in this matter was in 22nd of August 2023. That had directed the opposite parties to file their affidavits. But unfortunately, nothing has been done.
So matter has not been ready for hearing now.
as per your lordship's current roster, my lord is taking hearing in respect of classification. My lord, liberty to mention one revenue matter. My lord, since the year 2023, after retirement of Justice Nizamuddin, this matter has not been listed even once, and despite a complete direction for to be listed in the final hearing. My lord, the urgency is that there has been a penalty imposed on me by the state authority, and it has been realized upon coercion. The state
It has already been realized.
away from me, and the state GST officer.
There is no appeal. Provision for appeal.
The GST tribunal has not been established and made functional yet. Therefore, under Article 2.6, the Red Court has the jurisdiction, my lord. My lord will kindly take it up for the final.
Wait for some time.
May I be permitted for the inclusion? Lordship, this is a Group 6 matter, and affidavit has already been exchanged, and the matter is ready for hearing. Here, the urgency is the petitioner filed this petition for challenging a disciplinary order subject to
Or challenging?
disciplinary proceeding order. Subject to a penalty, his basic he had one increment down from his basic pay. Now he is going to retire soon, and now his promotion is also.
Wait for some time. Yeah.
17.
the senior citizen, my lord, he is not in a position, my lord, to cultivate. He has already got an order of permanent injunction, of decree of permanent injunction. Police was approached. Now, my lord, when this initial stage was, my lord, at the motion stage was moved, it was a direction of the lordship, my lord, to the police authorities to render assistance. By that time, order was passed, my lord, the cultivation period is over. Now, my lord, now at this moment, cultivation is now going on. When we have approached with that interim order, police authority saying, well, matter is pending, get it disposed of, get a fresh direction, only then we shall render
So
assistance.
on every season, court is to pass an order. Go on.
Order direction was there. I have got a permanent injunction, my lord.
So file execution case.
No.
File contempt.
My lord.
Before the court.
No.
Order.
Permanent injunction is there.
Huh.
My lord, only to implement. I want to implement, my lord, through police, my lord.
Civil court order, writ court will implement.
No. Tomorrow, my lord, if I go for execution, my lord, that will be, my lord, execution court will also, my lord, direct the police authority to implement it through police. No, my lord,
so go that forum. Why?
No, my lord, senior citizen, my lord, I have got a decree, my lord.
Senior citizen, that means senior citizen, no rule. Senior citizen, we will give precedence over the other matter following the direction once passed by the Honorable Supreme Court.
10 years, my lord,
but for senior citizen, law will not be different.
Definitely.
Okay, there is alternative remedy. Why? There is a procedure, execution proceeding, civil court first order. Now a new tendency has come. After getting order, file a writ petition and enforce the order.
Court order is not being implemented by the police. Also, kindly visualize the situation for the executing court, the civil court. Writ court order is not being implemented by the police, my lord.
So you have to file application for police help.
That is why exactly, my lord.
Police help before that court.
I have, my lord, direct. I have, my lord,
before that court.
Even, my lord, with my cost, my lord, I am ready to, my lord, render.
208 civil rules and orders.
Not that, my lord. My lord, interim order.
And 151.
Initially, my lord, interim order was there. Directing.
Okay, police help.
Directing the police in this writ petition, interim order was there, directing the police authorities to render assistance. That
everyone is coming to execute or to enforce the civil court order in the writ court.
Throw me out, my lord.
Now writ court is to act as the executing court of civil court.
No, executing court, my lordship, I'm at the cost of repetition, my lord. Executing court, my lord, civil court, that will be implemented by police. Now, writ court order, my lord, police is not taking care of.
Ultimately, what order you want? You want the police authority to act as per the decree?
Yes.
Yes.
To implementation of the decree.
Yes. So you have come here to enforce the decree?
Yes. With the assistance of the police.
It is a tendency going on.
With the assistance of the police.
Short route.
Well, at the initial stage.
Execution case, proceedings, it will take time. So find out a short route. What is the short route? Now the writ proceeding is a shortcut method.
It has
file an application, then come in action.
It has arisen out of the inaction of the police authorities, my lord. When police authorities seeing, my lord, there's a permanent injunction, my lord, it is a duty of the police to render minimum assistance, my lord, to the person concerned who has got, my lord, fought, my lord, for 10 years to get the decree.
Admittedly, you are correct, but there is a forum where this issue is to be agitated. And the writ court, due to existence of alternative remedy, generally will exercise the rule of self-restraint. You know very well better than me.
With deepest humility, my lord, I'm asking a question to myself, my lord. Police, my lord, take a stand? My lord, go and get it disposed of. Only then we'll act on it.
What? One police officer has said that based on his one stray comments, the court will not act.
No. Interim order of this.
Police has given written
written. Interim order is there before this court. Interim order is before police officer. In this writ petition.
So file contempt application.
Can you get it disposed of? Can you get it? Throw me out.
If you think that the interim order passed with this court has been violated, file contempt application.
Well, I know it. Kindly give me.
And you say which is of the words coming from this court is unreasonable.
No, not unreasonable.
I shall amend it.
Kindly update it, my lord.
দিনে আর কি for some time it could be don't say again and again wait for some time. Mere inclusion will not serve the purpose. Only 700 matters is my list. I am to dispose of the same. Wait for some time. Wait for.
My lord,
Pending before the ACLD, there is a specific direction or lordship to treat the matter under reasonable. There is no.
This code.
This particular case, the order lordship direction. That is the direction.
It will come under the heading returnable matter.
Not yet come. That's why I am mentioning the.
Okay, it will come returnable matter. যেটা বলা হয়েছে. Yes.
my lord, may I mention, my lord?
Okay, wait. Yes. Okay, to be mentioned.
379 of the combined list is the partners of the animal husbandry department. They are in serious financial distress, my lord. So some precedence may be given, my lord, in this matter.
Regularization or benefit of 60 years.
Not regularization, but they
Or benefit of the circular of the government.
no.
That you have to.
First petition of the court, they were absorbed, but thereafter the financial benefits are not being given.
They are getting salary.
No, they have to be given an honorarium sort of thing that is not being given. So they are in financial distress.
Item number?
379.
Okay, update it.
My lord, one matter,
I've given notice.
compassionate appointment. My writ petition was allowed. In appeal, my lord, the matter has been remanded back, my lord, for hearing. It is a compassionate appointment. That is why, my lord, urgency, my lord. Kindly, my lord. Any day in the supplemental list.
No, inclusion.
Yes.
Hearing matter.
On remand, it has been seen.
It would be under the heading hearing.
My lord,
Under the heading hearing, then under the heading hearing.
there is a supplementary list, my lord. Kindly.
And you are in the back row.
My lord.
Assign matter. Which assigned? Civil division. Civil division assign matter. Yes.
My lord, I'm paying for upgradation, my lord. I have served the copy. The petitioner is an Anganwadi worker, my lord. And Anganwadi, my lord. And she's not getting her salary, my lord. Since long, my lord. Kindly update the matter, my lord.
Okay, upgrade করে দিন সরকারের মাথায় লিখে দেবেন all upgraded matter. No mentioning is required. All upgraded. Yes.
Mention a matter for upgradation, your lordship, item 621 of the monthly list, your lordship. Your lordship, in this, the petitioner has not received the subsidy which was to be given by.
The subsidy is What is the urgency? Why it would be included? Keeping other matter. Okay, no mention, no urgency.
2018, my lord. What was obtained when the loan has been paid, my lord, bank gave no liability certificate. When returned the document, then they on reason that we did not return, so I filed it application. Now they have sent a letter that you have to pay rupees 10,000 more. If the court asks me, I shall pay 10,000.
Only for 10,000. You wait. You can pay it without prejudice to your rights and contention. Then at the time of hearing, what will be the decision binding? You pay.
They gave no liability certificate.
You make an application that I can pay without prejudice my rights and contention raised in the writ petition. Okay. For 10,000, don't.
Old matter, my lord. 200.
Old matter, I know. What is the urgency?
Urgency, my lord.
Old is relative word.
My lord, Panchayat matter without sanction plan, my lord, construction is going on, my lord.
There is a bench.
No, my lord, the hearing matter, my lord.
Whether that matter, that bench cannot take hearing matter. There is a bar.
Your lordship, I think, my lord, your lordship.
I know I have irrespective of classification, but the concerned bench which is taking motion, there is a bar that concerned bench which is taking motion shall be debarred from taking hearing matter.
That is not correct, my lord.
I do not find any such words. You go to the concerned bench.
Only my lord, hearing matter, your lordship, jurisdiction on that count, my
How many matters I will include? Mere inclusion, I know is short point. None can come with big point. Big point, they will go elsewhere. And I am also unable to handle the big point also.
Now they are saying that you have to pay $1,000. So we have to sell it. I do not.
90,000 here you have increased. Standing here in the court, you increase 90,000. It is monetary. It is monetary. You can write that I can deposit the amount without prejudice my rights and contention, and if it is found at the time of final hearing that their demand is unjustified, then must be that there's a direction that you refund the amount. Okay, Didi.
Higher scale of pay, lordship, upgradation following Utpal Kanti Karan, lordship. Complete.
This is. I'm mentioning about notice, this hearing matter was taken up thrice. When thrice the other side took time. Everything is complete. There is a promotion matter. When the next round of promotion, when the petition is in Group D, his co-workers will have reached Group B now. They have been given Group A.
It is running in the list.
It's running in the list, my lord.
It would be taken up. Don't worry.
It's in the monthly list.
Monthly list, it would be taken up. Monthly list, it would be taken up. If not taken up, you will mention.
Lord, under
Okay, it would be taken up.
compelling circumstances have come. Petitioner is a headmaster, 59 years of age. Now there was a criminal case initiated against him, for which he was suspended. Now that he has been honorably acquitted, not connected to his service. Now, my lord, when he has come back to join his post, he has been demoted to the post of assistant teacher, and the post of headmaster is being filled up by another teacher. Any day that can be done, my lord. And I'm at the 59 years of my age. So this is the situation. The very precarious condition. Kindly consider the stigma he has. The headmaster is discharging duty as an assistant teacher today in school, and he's not being allowed to render his service, my lord. Kindly consider. There is a very serious issue.
In the list?
No, it is not in the list. Kindly allow. 59 years, kindly, my lord. 59 years.
Hearing includes.
I'm extremely grateful to your lordship.
My lord, upon noticing the other side, may I be permitted to mention a matter for inclusion? My lord, the urgency is that the responded authorities, without putting up any justifiable cause, has stopped the admissible subsistence allowance of the petitioner. My lord, the subsistence allowance has been withheld since 2013, and it is a 2012 matter. Affidavits have been exchanged.
Since 2013, you are under suspension.
Yes.
The proceedings has not been concluded as yet.
No, proceedings have been concluded.
So?
Direction has been passed by the
So have you been succeeded, or you have been dismissed?
No, I have been succeeded, but order have been passed in my favor to release.
You have been exonerated?
No.
What? Disciplinary proceedings has been dropped?
No.
Or holding you not guilty?
An FIR has been lodged against me, and that has been quashed.
Disciplinary proceedings has been quashed. Now you have joined.
I have not joined, my lord.
Why?
My age has exceeded. So
that means you are, in the meantime, you have retired from service. You have got the benefit.
I have got the benefit for just few months, and since 2013, it is not.
Now you are getting pension. In which department you are employed?
Class 4 staff, a non-teaching staff.
In which department?
In Banachati Bharatiya Hindi High School, Durgapur. My lord, the petitioner is suffering.
10,000 for 10,000 in wait for some time.
They are now after one time when pay the 10,000. But they are
hearing a dhuki rikhi din tabar padega.
Kindly inclusion this matter, lordship. Group 6.
What is the urgency?
Lordship, urgency is that the petitioner is the employee and he has challenged one disciplinary proceeding order where he is suffering one increment down from his basic pay, and which will not be reverted back until Read Court pass this order. So and he will be retired.
Okay, wait for some time. No, you have mentioned
My lord, may I permit to mentioning for hearing matter, my lord, in item number 293 before your lordship the monthly list. Lordship, that in this matter, the petitioner obtained award from the insurance ombudsman.
From
the insurance ombudsman. Subsequently, insurance company filed writ petitions, and the matter was taken up. And according to me, in honorable court order, insurance company deposited 50% award before this Registrar General of this court. My lord, petitioner in the meantime suffering in financial hardship, my lord. Fix this matter.
No, wait for some time.
My lord, in this matter, fixed in any day, my lord.
Wait for some time. Oh, yes.
My lord, may I be permitted to mention one matter, item number 325 of your lordship's combined list.
Yes.
Urgency is that peculiar fact. Since 2017, a disciplinary proceedings has been initiated against the petitioner. In the year 2024, the Honorable Justice Rajashekhar Manta set aside the punishment on the ground that process initiated against the petitioner is mala fide, and now petitioner my lord wants to join in the service. Now the Satragachi Cooperative Bank restrain him to join. That is the whole thing. Disciplinary proceedings already set aside by the honorable court. Now I have to join my post. They are now refusing me to join in the post.
Okay, yeah. The updates.
My junior is there, Sunanda Chatterjee. He will.
Yes. Update. Yes.
My lord, may I mention, my lord?
Yes.
Actually, this is College Service Commission matter where almost nearly 20 petitioners for the post of assistant professor of a different subject matters. My lord, this was for hearing. It was almost on hearing before Justice Jai Sen Gupta in a previous determination. Now, my lord, only thing we request, let this matter be included in your lordship's the cause list, and then let it come in its own time. My lord.
Okay. Wait for some time. It will be included. Don't worry.
My lord,
Yes.
my lord,
Wait for some time. Wait for some time. Yes. Okay.
All right. Yes. Great.
Yes. Call the list.
Item number 1. My lord, I beg to appear on behalf of the petitioner in this matter.
Yes.
My lord, last occasion, lordship heard this matter. This is regarding regularization of a contractual employment against the sanction vacancy, as well as getting the benefit of the government circulars. Now, my lord, in very nutshell, I tell you, this is the 5th round of litigation. Now, the petitioner joined against a sanctioned vacant post against the vacancy of Gram Panchayat Kormi.
Yes.
And the documents clearly say that he was appointed against a sanctioned vacant post. Now, my lord, similarly circumstanced other candidates have been regularized, but the petitioner has not been. Now, my lord, several rounds of litigations was preferred. On every occasion, direction came for consideration by the concerned authorities. Now, my lord, one authority, one after another, playing me like a football, sending me from this department to that department. One department is saying, I am not authorized, you go to that department, that authority. Joint secretary is saying, you go to the principal secretary. Principal secretary says, I do not have the jurisdiction. You go to that person. This is going on, and they have also accepted my engagement. But what happened subsequently, during pendency of this litigation, through filing affidavits, they change their stand. Suddenly they change their stand and they come up with a new document showing that, no, your appointment was not, your engagement was not against a sanction vacancy. But previously there was contrary document which said that, yes, your engagement was against a sanction. Now, my lord, if we move ahead of this submission, now the whole moot point comes to that my appointment was irregular or illegal. So, my lord, we all are aware of the presence of the judgment of Umadevi, and very recently I'll be relying upon the judgment of Jaggu that your lordship has considered on the earlier occasion. My lord, there is no doubt that I have worked more than 240 days. It's been since long, in 2011 he has been doing. There is the same duty I am discharging. There is no blemish against me. And the government kept on changing its stand one after another. Now I show to your lordship very few pages. My lord, kindly take the writ petition for once. Yes. My lord, kindly come to page number 24. This is very vital.
Yes.
My lord, kindly see. It is of 2011, right hand side top, 11th November 2011. report on casual daily rated worker, contractual workers. My lord, kindly see the last name, that is Mahyuddin, Muhammad Mahyuddin, who is my client. My lord, kindly see the third column, casual worker, number of days service is 264 in a year. Whether engaged against sanction post? Yes, sanction. Lordship found it? Yes, I'm grateful to your Lordship. If yes, name of the sanction post? Casual. Now, my lord, kindly see the next page, 25.
It was issued by a Pradhan.
Yes, they are the authorities. They are the authorities. I'll tell you, Lordship, it has been sanctified by the BDO also. Now, my lord, kindly take the next page. Regarding approval of for permanent casual daily rated contractual workers, step was taken by the concerned BDO in regard with other similarly circumstanced person, and it was sent for the commissioner, but I was left out. But they have been considered. Now, my lord, I kept on making applications that were not considered. Now, my lord, kindly come to page 48 for once. That is pursuant to an earlier order of this honorable court. The concerned DPRDO passed an order. I draw your lordship's attention to page 49, the relevant portion. Whereas, as per record, that is this resolution taken by the Pradhan, such and such Gram Panchayat, dated 24th of April 2007, the petitioner is serving as a casual worker in the office of the Pradhan of Shahapur 2 Gram Panchayat from May 2007. And whereas the Commissioner Panchayat and Rural Development West Bengal with a memo number such and such dated 20th of May 2013 sought a report of such casual contractual daily rated workers engaged at different offices under Panchayat and Rural Development Department under jurisdiction of Uttar Dinajpur district to carry out the order of the Finance Department with a number 9008, that the financial benefits were not given, dated 20th of May 2013. And whereas the name of the petitioner has not yet been forwarded through from the concerned block development officer to the appropriate authority. Hence, the concerned BDO is instructed to send the said name to the appropriate authority at his earliest. So, my lord, it was for the DPRDO says that his name has not been sent. You send his name for regularization. Now, my lord, kindly come to page 50. Pursuant to the direction of the DPRDO, the BDO sends it to the appropriate authority. Relevant portion at page 51. Kindly take 51. Kindly see my name. The details are there. Matlab, contractual number of days service in each year 243. Whether engaged against sanction post? Yes. If yes, name of the sanction post, Gram Panchayat Karmi. It is their document. This is BDO's document, no more Pradhan. Because the DPRDO says that you send his name, he is entitled for. Now, my lord, kindly come to page 85. I'm not troubling your lordship with the other orders. My lord, kindly come to page 85. Pursuant to a previous order of this honorable court, my lord, kindly take the voluminous paragraphs. It's starting from it also appears. It also appears that the petitioner filed this writ petition against the impugned order of the commissioner, Panchayat and Rural Development West Bengal in the Directorate of PNRD at such and such place, video number dated 25th of July 2014, that Sri Muhammad Mahyuddin, the petitioner was not engaged against any sanction post, and Pradhan had given appointment to the petitioner without approval of the government in connection with WP number such and such. But the undersigned, as commissioner in the Panchayats and Rural Development Department, does not look after the matters relating to establishment of Panchayati Raj bodies cell, PRI cell in the PNRD department, and Sri Das, the Joint Secretary in charge of PRI cell at present, looks after the matters relating to establishment of PRI cell such and such in this department. Such and such memorandum, my lord, kindly skip over a bit, dated 16th of September 2011. The final approval in this regard will be given by the ACS Principal Secretary as the case may be of the concerned department, after exercising necessary checks and balances and ensuring that any ineligible person does not get the benefits of this order. In view of the above, it is hereby ordered that the matter be referred to Sri Das, Joint Secretary to the government of WB and PNRD department, for taking a decision with approval of the competent authority of this department. First striking feature, first time the state authority in the year 2019 is saying that no, your engagement is not against a sanctioned vacant post. I showed two documents to your lordship that it was against a sanctioned vacant post. One. Secondly, though the authority says that he is not allegedly not the appropriate authority, but observes gives a negative remark that no, you are not eligible, but I'm sending it to the other authority. Now, my humble submission before Lordship, I pose this question to myself. If he does not have the authority, can he send it to the another authority with a negative remarks? Then what is left to be decided? I pose this question to myself absolutely. What is left to be decided by the other authority? Such higher authority of Commissioner of the Panchayat and Rural Development sending it to another authority with a comment that no, he is not entitled, but I cannot decide it. Then if you are not deciding it, you don't decide it. You don't seal my fate and send it to the another authority for mere formality. Now, my lord, kindly come to page 88. That is the observation. My lord, kindly see the order portion. Observation portion, my lord, I'm placing. The petitioner was heard on 8th of March 2021 after careful perusal of the relevant papers, documents in connection with the instant matter. It appears that the petitioner was engaged as a casual worker at Shahpur 2 Gram Panchayat under Golpoket 2 Panchayat Samiti in the district of Uttar Dinajpur on 17th of September 2007 and has been discharging his service till date. It is also seen that he has worked for 240 days each year. Apparently, it is observed from the available documents that the petitioner was engaged against a sanctioned post. Now, kindly see the appropriate authority special secretary is observing this. Every day the color is changing like a chameleon. But kindly see the order now. After having gone through the matter carefully, I am in the opinion that as I am not been the competent authority to grant the prayer for awarding financial and other benefits as contained in the Finance Department's memo number such and such, dated 16th of September 2011, in case of the petitioner was engaged against sanctioned post before 1st of April 2010 and completed 10 years of service, rendering at least 240 days every year. And in case of EO, AEO of concerned Jilla Parishad, endorses that above stated matter in the prescribed proforma annexed to the Finance Department's above stated memo, his prayer can be placed before the competent authority as per the provisions of the above stated memo in this regard. Very shocking and surprising. The commissioner sends this to the special secretary accepts it, that yes, he is eligible, but now I do not have the authority. And my lord, I pose this question to myself, this poor person, the common citizen, will run from this pillar to that pillar for his consideration, despite there being an order of the Honorable Court, when you are accepting my eligibility. Now, it does not end here. My lord, kindly take, kindly see, my lord, even after the observation of the principal secretary, special secretary, what has happened, how I have been treated so far. My lord, kindly take the affidavit in opposition for once. Kindly take the trouble to take the opposition. That is affirmed on affirmative data down na to tomar abar. Ta amader opposition. The advocate on record is Habibur Rahman in this affidavit in opposition. My lord, kindly see the first annexure, page 8. The lordship has found, my lord?
Yes.
Yes, sir. 1st of November 2021 document, left hand side, 1st November 2021.
1/11/21, yes.
I'm so grateful. I'm so grateful.
Yes.
Now, this is a status report, not an order. But kindly see the last paragraph. Based on the report submitted, Special Secretary of this department with a memo number such and such dated 7th of October 2021, duly informed Additional District Magistrate and Additional Executive Officer Uttar Dinajpur Jilla Parishad that petitioner Muhammad Mahiuddin, son of late Kafiluddin, is not entitled to get any privilege enshrined in the memorandum number such and such dated such and such. I'm not troubling your lordship. All of Finance Department, Audit Branch, Government of West Bengal, as the petitioner does not fulfill the terms and conditions of those memorandums. Kindly see, again the color has changed. Now what they are saying, now they are not disputing that no, you have not been engaged as a contractual employee against a sanctioned vacant post. Now they are taking another path that no, you are not eligible to get the benefit of the circulars and notifications, which were principally brought to give the benefit to the contractual laborers. I'm not laborers, I'm sorry, contractual engagement. They are accepting the fact that yes, you are contractual. You have rendered service more than 246 days in a year. Your engagement is against a sanctioned vacant post, but you are not entitled to. For what reason? It is silent. It's a cryptic order. It's a cryptic status report. It is silent. It does not say why I will not get it. They simply say, no, you will not get it. For what reason? Is a non-speaking order. Now, my lord, kindly take the next page for once.
Yes.
Next page, that is the memo dated 7th of October 2021. Again, the same thing. My lord, kindly take the first paragraph. With reference to the above mentioned subject, the undersigned is to inform him. It is clear from his report that Muhammad Mayuddin was neither engaged against any sanction post in Shahpur 2 Gram Panchayat under Golpoke 2 Panchayat Samiti, nor was issued any sanction approval from the block development officer, Golpur 2 block, towards such appointment, and thus the petitioner does not fulfill the criteria of the above mentioned memorandum of Finance Department to receive such benefit. Therefore, petitioner Muhammad Mayuddin is not entitled to get any privilege enshrined in memorandum number such and such, Government of West Bengal, as the petition does not fulfill the terms and conditions of the above memorandum. Another shocking feature of this memorandum. Kindly see. The commissioner holds that the special secretary is the appropriate authority. He founds it. Yes, you are eligible. The BDO, the DPRDO, Pradhan, everybody holds that yes, you are eligible. Now, this comes in as late as 2021, saying that with reference to the above mentioned subject, the undersigned is to inform him. It's clear from his report filed by whom? Additional District Magistrate. I pose this question to myself, whether this post is above the post of Special Secretary, of the post of Commissioner. The respectful answer is in negative. No. Once the higher authority holds and observes, the lower authority has no authority to deny such observation or to dispute such observation. This is the basic fundamental principles of service jurisprudence. The additional district magistrate does not have the authority and jurisdiction to give a finding against the special secretary. It is at the secretariat level. Now, what they are saying, nor was issued any sanction approval from the block development officer. This is also incorrect. I showed to your lordship that block development officer, in terms of the order of the DPRDO, has categorically submitted that yes, he has been engaged, which has been accepted by the special secretary. Now, this color changes. As if my client is going through a litmus test every time. Every time you put him, the color is changed. This is purple or white or green, whatever. It is going on. Since 2007, 18 years, he is languishing 5th round of litigation for this.
It is a 5th round of litigation.
5th round of litigation. This person is with this hope and expectation. He is fighting for his case for last 18 years. And today he is standing before your lordship. 18 years. No benefits, nothing. It's going on. Now, my lord, kindly see the next page, dated 30th of September 2021. Again, my lord, the DPRDO sends it to the additional district magistrate. Submission of report, serial number 1. As per previous available report of the BDO, is memo number such and such, which was sent to this end against specific requisition regarding list of casual delegated contractual worker engaged. Muhammad Mayuddin was not engaged against any sanction post. The name of Muhammad Mayuddin is placed at serial number 44 of the said list as ready reference in the copy of said report duly signed by the BDO is attached herewith. As per recent report of the BDO, no approval or sanction had been given from the BDO, Golpoke 2, regarding appointment of Muhammad Mayuddin. Again, as per recent report of the BDO, could not submit any of the papers in original. Gram Panchayat could not submit any documents in original related to the appointment of Muhammad Mayuddin. But kindly see, after acceptance of the commissioner, special secretary, now the DPRDO, who had previously given the consent and nod, as well as the BDO, now both of them are changing colors. For what reason, I do not know. Maybe I could not satisfy their expectation. If I use the better word, I could not satisfy their expectation. Now they say, as per latest report. So you mean to say the previous report was wrong? You have to cancel that report then, officially, that report was erroneous? With change of stance, with change of stand, and with change of guard, the decision of the government cannot change. But this is a fundamental principle. It's my respectful submission. The decision of the government cannot change with the change of guards. On that time, one BDO was there, he gave one report. Today, some new person is coming, he is giving another report. Cannot be. Cannot be. You cannot make out a new case here when you have already accepted it and it has gone up to the special secretary. He has approved it. Yes, you are eligible. Can this lower authority, with deepest respect I submit, has the jurisdiction, power to say that no, he is not eligible, meaning thereby denying the decision, disputing the decision of the special secretary? Does this authority have any power and jurisdiction to override the decision of the special secretary? I pose this question to myself, and the answer in my most respectful submission is in negative. Cannot be. It is not permissible. Once the higher authority has decided, you not being the appellate authority, you cannot overturn the decision of the higher authority. You are not the appellate authority. From where are you coming with this? And the special secretary has not casually passed that order. In terms of court's order, he has done it. As per the request of the commissioner of Panchayat Cell, he has done it. Not casually, upon going through all the documents. Now you cannot change the stand. Now, my lord, these all are the factual considerations. I know my learned friend will also submit certain documents on this point, possibly. Now, my lord, what is the stand today? Good, bad, indifferent. At worst, I may be called as an irregular appointee. Nobody is saying that I'm illegal appointee. Nobody is saying that I'm illegal. They are saying that no, you are not against the sanctioned vacant post. Nobody is saying no, his appointment was illegal, he should be thrown out here and now. Nobody is saying. Nobody has terminated my service, nothing. So my engagement is not illegal. At best, it can be irregular. Now, my lord, I take the privilege to place this judgment 2024 Supreme Court cases online SC 3826. It kindly Judge. Though your lordship is well aware of this judgment, for to bolster my submission, I'm submitting before your lordship. My lord, I would draw. This is Jago versus Union of India and others. My lord, I will not trouble your lordship. It is on the similar point. I will draw your lordship's attention to paragraph 12 onwards.
Yes.
My lord, may I? Despite being labeled as part-time workers, the appellants performed these essential tasks on a daily and continuous basis over extensive periods, ranging from over a decade to nearly 2 decades. Their engagement was not sporadic or temporary in nature. Instead, it was recurrent, regular, and akin to the responsibilities typically associated with sanctioned posts. Moreover, the respondents did not engage any other personnel for these tasks during the appellant's tenure, underscoring the indispensable nature of their work. Next, the claim by the respondents that these were not regular posts lacks merit, as the nature of the work performed by the appellants was perennial and fundamental to the functioning of the offices. The recurring nature of these duties necessitates their classifications as regular posts, irrespective of how their initial engagements were labeled. Well, kindly mark this statement, this observation. The recurring nature of these duties necessitates their classification as regular posts, irrespective of how their initial engagements were labeled. It is also noteworthy that subsequent outsourcing of these same tasks to private agencies after the appellant's termination demonstrate the inherent need for these services. This act of outsourcing this effectively replaced one set of workers with another, further underscores that the work in question was neither temporary nor occasional. That is not applicable. Next. The abrupt termination of the appellant's service following dismissal of their original application before the tribunal was arbitrary and devoid of any justification. The termination letters issued without prior notice or explanation violated fundamental principles of natural justice. It is settled principle of law that even contractual employees are entitled to a fair hearing before any adverse action is taken against them, particularly when their service records are unblemished. In this case, the appellants were given no opportunity, but that is not quite relevant in my case. Kindly come to paragraph 16. Next page. The appellant's consistent performance over their long tenures further solidifies their claim for regularization. At no point during their engagement did the respondents raise any issues regarding their competence or performance. On the contrary, their services were extended repeatedly over the years, and their remuneration, though minimal, was incrementally increased, which was an implicit acknowledgement of their satisfactory performance. The respondents' belated plea of alleged unsatisfactory service appears to be an afterthought and lacks credibility. Now, my lord, kindly skip over a bit and kindly take paragraph 19, the next page. It is evident from the foregoing that the appellant's roles were not only essential but also indistinguishable from those of regular employees. Their sustained contributions over extended periods, coupled with absence of any adverse record, warrant equitable treatment and regularization of their services. Denial of this benefit followed by their arbitrary termination amounts to manifest injustice and must be rectified. It is well established that the decision in Umadevi, Supra, does not intend to penalize employees who have rendered long years of service, fulfilling ongoing and necessary functions of the state or its instrumentalities. The said judgment sought to prevent backdoor entries and illegal appointments that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can over the time transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In a recent judgment of this court in Vinod Kumar versus Union of India, it was held that the procedural formalities cannot be used to deny regularization of service to an employee whose appointment was termed temporary but has performed the same duties as performed by the regular employee over a considerable period in the capacity of the regular employee. The relevant paras of the judgment have been reproduced below. I'm not troubling your lordship with the judgment. Paragraph 21. Kindly take paragraph 21. The High Court placed undue emphasis on the initial level of the appellant's engagements and the outsourcing decision taken after their dismissal.
Yes, I have read.
Yes. Paragraph 22, my lord. The pervasive misuse of temporary employment contracts as exemplified in this case reflects a broader systematic issue that adversely affects workers' right and job security. That much only. I'm not troubling your lordship. Last paragraph. It is a disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. This practice manifests in several ways. In light of these Paragraph 27. In light of these considerations, in our opinion, it is imperative for government departments to lead by example in providing fair and stable employment, engaging workers on a temporary basis for extended periods, especially when their roles are integral to the organization's functioning, not only contravenes international labor standards, but also exposes the organization to legal challenges and undermines employees' morale. That much I am placing. Now, my lord, this is the latest development. To what extent from Umadevi, there is a long journey from Umadevi to Jaggu's case. Now, what is the difference now? As I humbly understood and I placed before lordship, the Supreme Court has taken a further step. It is not only limited to backdoor appointment, illegal appointment, irregular appointment. Now, the present consideration is whether he has been rendering his continuous service without any blemish or not. On this foundational fact and consideration, this judgment is standing. That whether he has rendered service, have you stopped him? The government, has the government stopped him? No. Is there any allegation against him? No. He has rendered service, you have extracted his service. Maybe his initial engagement was irregular. Then at this stage, you cannot say, no, we will not regularize you after extracting service for a prolonged period. Now, again, the Honorable Supreme Court considered this issue, that this irregularity and illegality, even if it is irregular, by virtue of rendering a prolonged service, you have secured, you have cemented your place. Today, it cannot be said, no, I will not consider you, though I have extracted service of the regular employee. I pose this question and I humbly submit, is there any statement found anywhere which says that, no, he has not rendered his service? Any allegation?
When you are engaged?
2007. No? 2007.
It has not been annexed, my lord.
No, 2000. It is recorded.
And condition.
It is. It is recorded. It is recorded in the commissioner's order since 2007. 18 years. Similar service. No allegation. Nothing. And every time more than 246 years, your lordship has seen. But till date, when especially the special secretary holds it, yes, you are entitled. possibly one authority with an enlightened mind has found it right. Yes, you are. And I'm squarely covered by this judgment, which says on this line.
Yes.
This is my humble submission before Lordship. I'm grateful to Lordship.
My lord, so far, my lord, initial appointment has not been engaged. What are the terms and condition of his service is not reflected from the writ petition. My lord, so far, the post is concerned, we have shown that it is not the sanctioned post. If it is not sanctioned post, your lordship knows very well, the court cannot give to create the supernumerary post to regularize him. And my lord, so far his allegation is concerned, I have dealt with in paragraph 4 of my reply as per direction of the earlier coordinate bench, my lord. Your lordship kindly see, in compliance with the Honorable Calcutta High Court's order dated 8 December 2020, a hearing was arranged on 8 March 2021. Your lordship got it, page 2.
Affidavit in opposition.
Affidavit in reply, because my lord, we have filed initially report. On the basis of the report, he has used affidavit in opposition, and against his affidavit in opposition, we have filed the affidavit in reply.
Yes. Yes, got it. 4A.
4A. In compliance with the Honorable High Court's, Calcutta High Court's order dated 8 December 2020, a hearing was arranged on 8 March 2021 in the Department of Panchayat and Rural Development. The Special Secretary of this department heard the petitioner. Since the report from the District Authority, Uttar Dinajpur, over the claim of the petitioner as unavailable during the time of hearing, the Special Secretary of this department relied on the documents submitted by the petitioner, and there was no scope to get them verified by the District Authority from their office record. The same was reflected in the order dated 9 March 2021, issued by the Special Secretary of this department, whereby it was stated in the observation part that apparently the claim of the petitioner seemed justified against the documents submitted by him, which is a conjecture. It was also stated that if the inquiry officer or additional inquiry officer of concerned Jila Porishad endorses the above stated matter in the prescribed pro forma annexed to the Finance Department memo number 9008 FP dated 16th September 2011, his prayer can be placed before the competent authority as per the provision of the above stated memo in this regard. Hence, it is very clear the entire final decision in this matter is dependent upon the issue of submission of pro forma report by inquiry officer or additional inquiry officer of the district Uttar Dinajpur. Since no report in the prescribed for pro forma was received from the district authority Uttar Dinajpur at that time, no final conclusion over his claim could be drawn. The additional district magistrate and additional executive officer Uttar Dinajpur Jila Porishad by memo number 403 Panchayat dated 30th September 2021 submitted report in prescribed pro forma in the matter. Based on the report submitted by the additional district magistrate and additional executive officer Uttar Dinajpur Jila Porishad, the Special Secretary of the Panchayat and Rural Development by memo number such and such dated 7th October 2021 duly informed that petitioner is not entitled to get any privilege enshrined in the memorandum dated 16 September 2011 and my lord, other my lord,
have you annexed this memorandum?
No, my lord. They have not annexed, we also not annexed.
What is the provision of these circulars? What is the subject matter of this circular?
Circulars, subject to correction by my learned friend, this circular says, lays down certain conditions that their service is secured up to 60 years of age, and that they will be given one-time ex gratia after their retirement.
That circular.
That's a 9008. Now it says the enhancement of pay also.
Another again rudimentary factors is the post must be sanctioned one. If your lordship wants, I can produce also that circular also.
Your Pradhan and BDO to try twice or thrice on 2 or 3 occasions said he was engaged against sanction post.
But they have the not.
Subsequently, his claim is subsequently changed your stand.
Yes, Malad, but so far
no, it is not against sanction post.
But the
appointment was not
the appropriate authorities, the Malad, it should be placed at the prescribed format, and that has been done by the inquiring authority. That is, my lord, Uttar Dinajpur Jila Parishad is the appropriate authority. And there, one of the condition is appropriate authority should, in the prescribed format, should be placed it. Your lordship should look into.
So you produce the staff pattern as on that date. And what is the present state of affairs? How many staffs are engaged or working in your establishment?
It is already annexed with this.
Where?
That is placed before lordship, that my nomenclature has been given. Where against 246 days, against the Gram
No, no, no. What was the staff pattern? Since this act is coming, there is a contradictory stand. He is saying that no, you are not engaged in any sanctioned post.
Yes,
now you are trying to base upon the statement made by the block development officer and Pradhan.
No, as well as the special
apparently.
Special commissioner.
Special secretary says apparently.
Apparently, use the word apparently.
Yes,
apparently that it,
apparently is at the last portion.
That it appeared to him.
That is at the direction portion. In the observation portion, it says you are. It is at the bottom at the direction portion. Observation portion is. Now, my lord, kindly one thing, appreciates one thing. My learned friend, what has shown? Paragraph 4 ABCD. What are these paragraphs? Whatever I said, that is written in that paragraph. That has been done. Now, what is their stand? It has to, they are not saying that no, you are not eligible. They are saying you have to be placed before the appropriate authority. Two submissions.
Okay, you forget about who the court is. Court finds that your claim is justified.
Yes.
Court will direct them.
Absolutely, I'm grateful, madam.
Okay,
that's what I'm
and unless this direction is set aside by the Honorable Division Bench or the higher forum, they are bound to accept.
Absolutely, I'm grateful.
Okay, don't worry. But before giving that direction, actually, what is the problem? What is passing in the mind of the court? If there is no sanction post, you are seeking regularization.
Very well, madam. Very well.
Okay.
Very well.
Regularization means irregular appointment can be regularized.
Irregular, my lord.
Irregular, yes. I have consciously used the word
I'm so grateful.
irregular, but not illegal appointment.
Yes. Now, my lord,
Yes.
Umadevi and Jaggu.
Yes,
is on that
Umadevi,
point.
Jaggu, Vinod Kumar, I got occasion to deal with
All these judges. Yeah, I know. Sitting in the division bench. I know. My lord, only, may I just one.
Now, this question is to be determined first, whether you engage against sanction post or not.
Yes, my lord, may I just.
It is a core question.
Absolutely.
Now, admittedly, as per the documents as shown by you, there is a contradictory stance.
Yes.
Pradhan, excuse my repetition, Pradhan and video says that you engage against sanction post. Now, subsequently, the additional district magistrate and the secretary level says no, you are not engaged against sanction post. Now, Mr. Pal's submissions also is appear to be logical. He is saying that then court is to ask them to create supernumerary post. And then your engagement against that post is to be regularized.
May.
Unless there is a existing sanction post, direction for regularization cannot be given.
Yes.
So it would be better, I am inviting a report.
Only before that.
My lord,
before that.
From them.
Kindly.
You saw the step pattern.
Before that, I understood.
And how many employee was working as either as a contractual employee or as permanent employee. The picture will be clear, I think.
Now, my lord, now there is something very substantial I would like to submit. What has fallen from your lordship, I absolutely bow down to that. Now, there are two conditions. One, I am engaged against a sanctioned vacant post. So, I am a regular appointee. What is the other other stand? That I have not been engaged against a sanctioned vacant post. So that makes me an irregular appointee. If I'm against a sanctioned vacant post, I'm a regular appointee. If it is against a non-sanctioned vacant post, then I'm an irregular appointee.
No,
I'm not
In that
illegal.
circumstances, that will indicate another thing.
Then, my lord, we are transgressing Jaggu's
That
judgment.
means the process was not regular.
Absolutely.
There was some irregularity.
Absolutely.
Sanction post is there, but to fill up the post, the regular proceedings or applicable or proceedings which was required to be followed has not been followed.
Absolutely.
So the engagement or appointment, it is irregular, not illegal.
Absolutely.
So otherwise, would be the difference between irregular engagement or illegal engagement?
Now I remind your lordship two things. While going through the documents, the lordship has found that what it says exactly, what the stand of the government, it says that he has been engaged by the appropriate authorities. Rightly, I have been engaged, I have been discharging my service. Now, Jaggu's judgment is very clear on this, that if you are rendering your service continuously, there is no blemish against you, you are entitled. One. Secondly, what they say, in one paragraph, they say that they do not have sufficient documents. They could not place it. Your lordship has seen that in the one report. So today, directing them to come with documents, I don't know whether it would be an empty formality. Whatever document they had, there are four affidavits almost now. Nothing new can be placed and no new case can be made out today. 4 affidavits have been done today. Whatever had to be submitted has been submitted before your lordship. Now, going back to the regular point, my lord, I pose this question to myself, whether there is any question ever arose regarding my appointment, whether it has been done illegally. No. Nobody is saying that you have been appointed illegally.
To place that.
No, that is a different thing. No,
Mr. Lahiri. If any person is engaged or appointed, whatever term you can use, not against any sanction post. There is no sanction post. But the person has been engaged or appointed.
Service.
Now, according to you, how you will describe this appointment?
This is irregular.
Whether irregular or illegal?
Absolutely irregular. Why I tell you, lordship? My lord, there has to be a post.
Yes.
There has to be a chair where I can sit.
Yes.
There has to be a chair. So the post was there admittedly. There is no question that no post was not there. He has been taken illegally.
That is the question, whether post is there or not.
Otherwise,
Posts were there or not.
It appreciates. Otherwise, the government would not have sanctioned my engagement remuneration. I have been getting the remuneration from the panchayat. How would I get it? It is sanctioned.
That can be given under any fund.
No fund. No. I'm getting regular engagement.
Actually, Mr. Lahiri, if this direction is given,
yes,
our finance department will be forced to pay salary and other service-related benefits. But against whom?
My lord is aware of
Must
the audit.
be against one post.
My lord is aware of the panchayat audit.
Mr. Lahiri, without giving spontaneous reply, you consider.
Yes.
Suppose you are the secretary of the finance department. Now you have to release certain fund.
Yes.
Towards salary and other service-related benefit. So where you will release? Against certain post. Everyone getting salary, since there is a post, the finance department is releasing fund or the amount against such post. The person will retire, may die in harness, but the government will go on releasing fund against that post.
It is an undisputed question.
Unless it is abolished.
My lord, this is
okay. So
undisputed
unless
today.
there is any sanction post, how the government can be compelled that you issue salary and other service related benefit in favor of a particular person?
My lord, I humbly respond to your my lord, supernumerary post does not come.
So
I never paid for supernumerary.
even I got the judgment. There is also judgment Sirpal, all Justice Bikramnath, Jaggo, Vinod Kumar. Yes.
Sirpal is last 25th April 2025.
Yes, Sirpal judgment is
My lord,
there.
I am not talking about the supernumerary posts. That is not my case even. What my submission most respectfully submit, my lord, for
every occasion your lordship has found in the documents that he has been rendering service against the vacancy of Gram
Rendering
Panchayat.
service. Against the whether against the vacancy or
Gram
sanction
Panchayat
post is
Kurmi, it
not.
has been written.
Let the court and make an inquiry.
Very well. I cannot stand.
Let the court make an inquiry.
Yes, absolutely.
Before passing any order, because
Very well.
a
But,
court,
my lord, I am only apprehensive on one thing.
court will pass that order which must be honored.
Absolutely.
Which must be honored.
My fear is otherwise. I am apprehensive on only one thing. My lord, only one thing. My lord, why
Acha.
I am apprehensive? Because they are changing stand. They will come up with something against me, which was not there previously. Your lordship will be relying upon that.
Lahiri, learned advocate. Don't worry, yeah, go. Yes, item number 222.
Two, my lord, I beg to appear on behalf of the petitioner. Again, my lord, is a cause of environment, restoration of water body. And my lord, what happened, lordship will find from the photograph, page 46, annexure P7.
Have you served? When you served? Yes.
Yes, my lord.
In 2019.
No, this is not 19.
It was last appeared 2000 years. That's Soumitra Bandyopadhyay for the state and Piyobrat Bhattacharya.
I may be allowed, my lord, to effect service upon them, my lord, and come back in any other date. I know Soumitra Bandyopadhyay.
Okay, acha. Acha, having heard the learned advocate appearing for the
The petition.
Yes.
I was a state manager.
But
I'm
the
for the
mat-
WBSC.
the matter relates to illegal running of sawmills. But the sawmills are running by the private respondents illegally, without having any license. But, the petitioner made representation to the concerned authorities at page 27 onwards.
So how your personal life is being infringed?
But he is the owner, sawmill owner.
Yeah.
Petitioner is the sawmill owner having valid license. And they are running illegally without having license. But may I so one judgment of this honorable court?
Yes.
By way of
Yes, the report, my lord. As per the report, my lord.
But may I please, my lord?
Okay, I'm coming to judgment. Let the court ascertain the fact whether first
Illegal sawmills, my lord. See the
Huh?
report. See the report regarding illegal sawmills.
Illegal.
No, my lord. So even now there is no illegal sawmill. Against section number 8 to 12 to 14. Only my respondent number 8 is there, Mr. Alam Sheikh. He got the permission from the Panchayat. And my other Mr. Respondent 9, 10, 11, 12, 13, 14. So we have stated the report regarding details.
No, so what is the outcome of that inquiry?
I'll see the report. Mr. Alam,
Oh,
middle part.
Later.
First outcome is that Mr. Alam is got the permission from the Panchayat.
It is not a Panchayat. No.
I'll see, we have managed the documents.
No, it is not a
You
Panchayat.
have made 8 to, that means
14.
14.
Kindly please.
That means 1, 2, 3, 4, 5, 6, 7. So 7%.
Yes.
You are claiming that 7% have been running sawmill illegally without any license obtained from the competent authority. It is your contention.
Kindly see, my
So
in the middle part, my lord, during inquiry, SI Manav Mondol, can you see?
Alam Sheikh have a sawmill.
Yes.
Alam Sheikh.
With permission.
As such, he produced no objection certificate. No objection certificate from whom?
Can you see, my lord, the annexer?
Who is for Alam? Whether any forest department has granted any license in your favor?
No.
No, applied. Whether your application was applied, sanction, most probably that rule 14.
Yes, my lord.
West Bengal forest produce and other wood-based industries rule.
Already I have submitted.
Only got permission from the Panchayat.
No.
No, Panchayat cannot. How Panchayat?
Yes. Only got permission from Panchayat.
Don't allow Panchayat to the omnibus. Powerful in there.
Rule 3, kindly rule 3.
West Bengal forest established of regulation of sawmills and other wood-based industries rules.
Yes, yes.
So,
May I place, my lord?
6, 3 and 14, 14. Which will?
Three, my lord. Circumstances.
Rule 3, yes.
Circumstances prohibiting establishment of sawmills, etc., and grant of license. My lord,
Subsection B.
Sub-rule B, without obtaining a license in form 1 issued by an authorized officer. That means not forest officer. But may I?
Only next.
You show the license in form 1, Roman 1, issued by the authorized officer. Otherwise, you shall not be permitted to deal with forest products.
May I place one?
How state? It is the stand of the state, whether it is a fair stand.
Only got permission from Panchayat, nothing else. So you need to have permission from the DFO, from the forest department, definitely. So the inquiry in the
one inspector in charge, he is saying.
He is not the authority, my lord.
This simply no objection, my lord. This is not the permission. Can you see the page, third page of my report, the annexure. Simply no objection.
Oh, that is not the permission.
Not even permission. That is only no objection.
Therefore, it's an illegal.
But no permission.
Therefore, it is a
And one
Yes, 3. So 3B or immediately between shall also obtain. So unless you granted license, why, what?
Regarding the other 9 to 14, there are no sawmill. They already closed. Can you see that as per our report?
There is no
There
is no
As for the 9 Malas Monjumir.
So divisional forest officer concerned and the police
Yes.
shall ensure
They are the
no sawmill is run by the private respondent or by any person without any license obtained from the authorized officer in accordance with law.
Yes, proper order. Your lordship can dispose of that.
Huh?
Yes, sir. But
You are representing the rest private respondent also. Alam Sheikh. Others have not come.
Others are not exist.
No existing.
No, another person. Nabu Sheikh, he has a sawmill.
He is running till now.
Huh?
No.
Till now. He is running till now, today.
Nabu Sheikh.
No, man.
All are till running. Till running.
He has sold.
And several other sawmills, illegal sawmills are running.
Regarding size Ali, no sawmill is there.
Candidacy already submitted.
আচ্ছা
বন্ধ করে দেবে বন্ধ করে দেবে
আসুন আসুন the petitioner comma a sawmill owner has আজকে দেরি হয়েছে।
On behalf of the petitioner, my lord.
Yes.
My lord, my father Subodh Kumar Sarkar was a license holder of a liquor shop. That was Country Spirit, flavored spirit, as well as the rum. License was there. Thereafter, my lord,
Liquor shop, then?
yes, my lord, liquor shop.
Then I couldn't
And we
follow.
running a shop. My father was running a shop.
Shop. Foreign liquor off shop.
Yes. Country liquor,
Country liquor.
flavored spirit,
Okay.
and rum 25.
Okay.
That was a shop. The license was being issued periodically from time to time, my lord. Now, my father died in 2017. So he had 6 survivors. 6 legal heirs were there. I am the petitioner. I am a practicing advocate at Bashir Hart. I am the eldest son. So in 2018, my lord, I made a communication to the...
You are a learned advocate.
Yes. I'm the learned advocate.
You want now license?
My lord,
In your name?
No, not in my name. It's in a joint licensee should be there.
Oh.
All the legal hair should
So
be.
in your name also?
Yes.
So Advocate Act has permitted you to
I'll
do a
come out with
business.
that. Come out with that.
You show.
One
That
thing-
Advocate Act has permitted you
My lord,
to
one
do
thing
a
has come up,
business,
my lord.
to run a business.
My lord, in the judgment, in the order which they passed by the additional district judge, my lord, it said out.
You remove your name.
No, he
Okay.
said out in the rule of Bar Council, as per the Advocates Act 49(1).
Yes.
The power of Bar Council of India has the power to make rules. So the rules were being set up by the
Yes.
Bar Council.
Yes. Okay. Very good.
Take into, my lord, the consideration they dealt out the rules of the BCI rules 47 to 51.
It is the cause they have rejected.
Yes, mother. That was.
Oh, really? Without knowing the fact,
Yes, my lord, kindly take to
So
50.
that-
I'm giving that one, my lord. I'm giving that rules, my lord.
So that issue as hand whether an advocate can run a liquor shop.
I'm not going to be there.
Or run a business or not.
No, my lord. I'm not in the management. I will be as a, my lord, kindly take 50, my lord.
Yes, a advocate shall not personally engage in any business.
Yes.
But he may be a sleeping partner.
No, that is on 40. 50, I'm saying, my lord. 50. Rule number 50, my lord.
50, okay.
Advocate who has inherited
Hmm.
or succeeded by the survivor to a family business may continue it, but may not personally participate in the management thereof. He may continue to hold a share with others in any business which has descended to him by a survivor or inheritance or by will, provided he does not personally participate in the management thereof. I'm ready to give out an undertaking. That is, I'm not going to personally be in the management. But, my lord, as per the inheritance, other legal heirs were given. In 6 out of 6, 3 were given the joint license. Whereas 1 was a handicap and 1 declined. One of the legal head declined to have out a joint license. So my license was cancelled for the reason that is because I'm an advocate.
Advocate, yes.
And even one more allegation they have put up, that is, I have suppressed that I am an advocate. But when the communication done in 2018 that my father died, I had communicated in my letterhead, in the letterhead of an advocate. There was no suppression to that. First allegation, that one. And the second, I've been an advocate as per the BCI rules of from 47 to 51, I will not be eligible for the joint license. So I have just found out a joint license also be issued and an undertaking can be given by me that I will not participate in the management, my lord.
Your rule most probably silent on this issue.
My rule says it's a discretion. Well, first of all,
it is discretion. Rule is silent on this issue. Yes, you will not find any clause in the.
At this point of time,
because advocate will sell such and such.
This is an order of 2020. This is an order of 2020.
Yes.
And
order of 2020, whereby you refuse.
Yes.
Yes.
Did not challenge, prefer any challenge, appeal. There is a.
Oh, there is a appeal.
It is a commissioner, thereafter state government. And I have come with the rules also.
So you don't raise the issue of delay, they will
No,
file
Malan,
appeal.
in 21, we filed the writ petition. Soon we got the order.
Okay.
They have came out with a writ petition.
Okay, writ petition means it is judicial review. It is judicial review.
Yes, Malan.
Let the appellate court
But,
take
Malan,
decision.
May only say this, but
And I think, and without reading, without looking into the brief, I have stated what may be the problem since you have voted. And I also said, plus, most probably the concerned rule, applicable rules have not addressed this issue.
no, Malan, they have
Okay.
addressed, absolutely addressed.
The advocate,
Yes, absolutely on that.
rule has addressed.
Yes, here it has been addressed. Now, my lord, there are two aspects. If today an appeal is preferred, or my lord has to consider the extent rule, which says only one sole layer can be, because the rule
Which says
2003 was the rule in 2020. Today, in 2025, there is a change of rules, where it says only one legal layer can inherit. But first of all, this is a legal license. This is not a question of a.
you cannot give retrospective effect of the present rule.
No,
You have to consider his prayer as per the
my lord,
the rule prevalent at the time of death of his father.
At the time, my lord, one by one, my lord. Can you come to page 40?
40
40.
of the writ petition.
Yeah, no, yes.
Okay, 40. Yes, page 40.
Yes. My lord, would start from the paragraph in today's hearing.
Yes, today's hearing.
Ready? So and so place the report submitted by DEC Boshirat along with the affidavit submitted by the legal heirs and other relevant documents. The legal heirs have also been heard at length. It appears that Sanjeev Kumar Sarkar, eldest son of the deceased licensee, has stated in his affidavit that he is a businessman by occupation and a resident of so and so. Whereas it appears from the report of DEC Boshirat and several other documents held by this office that he is a practicing advocate in Boshirat Civil Court. When asked for the reason of not mentioning his occupation correctly and specifically in his affidavit, and remained that such an act on his part amounts to suppression of facts from the collector, he submitted he is a practicing lawyer but could not explain why he had submitted incorrect information through affidavit. He expressed his intention through affidavit to be included as a joint license, or stated he will run the licensee as per government rules and regulations. Today, a stand has been taken that he will be a silent partner, so and so. Well, this was never the stand taken before the concerned authority. He will run the business, he has said. He will run the business, my lord. My lord, an order cannot be improved by affidavit or anything else subsequently. My lord, it has to be based on the findings. Well, it is a very much a clause now, my lord. Considering all this element, my lord would find after referring to the rule 47 to 51, he has rejected his prayer. He said
clearly debarred him to engage himself personally in any business.
Well, that is the finding. Well, he said he wants to run it. Today he said he will be a. How can we, with deepest respect, this license, excise license, please, excise license is a privilege that the state is giving him on the basis of some consideration. It is not an inheritance right. It's not a building or house he is going to inherit. It's a privilege that a person, his father was enjoying. Today, my lord, an order has been passed by the collector in 2020. After 5 years, he comes up and says to this court that he wants to change this.
He wants to
change this pattern. He wants to change. My lord, he has to now, after 2021 writ petition, but I have seen there is no order. So he never moved this writ petition.
My lord, I can place out several mentioning of this matter, my lord. My lord, it's a wrong allegation that has come up
He
here.
has not moved.
My lord, in 21 that was there. After 5 years, I'm saying that's a wrong part on my learned friend to say.
Today,
because in 21
lord,
I placed out this writ petition, my lord.
My lord, please. My lord, today, what is the material before your lordship? With deepest respect. No, that material is that he had applied, suppressing the fact that he is a lawyer.
You have not refused to grant license, joint license or such and such on the ground of suppression of fact.
No, suppression.
Rather you relied upon Rule 47 to 51 to claim that for being an advocate, by being an advocate, he is ineligible to get a license.
With some respect, would kindly, for my.
Yes,
he admitted.
It has been.
No, he admitted he is a practicing, but could not explain why he had submitted incorrect information, though, but through affidavit.
Yes, it is
one of the consideration.
One of the consideration, but it is not the core consideration.
I'm not saying that. Now I come to a conclusion that he has applied for running of the business. Today he takes a stand which is different from the original stand before the collector. But whether he has made the other years a party, whether today after 5 years, someone comes up and there's a change in the way. Ultimately, it's not a right. There's a excise license. It's not a fundamental. Knows it better than me. It's just a mere privilege that the state extends to a person against certain consideration. Against certain, it's not an inheritable right. Now the rule is more strict. The only one here can succeed out of the 4 years. And our 14(6) rule says, which has also been relied, my lord would find that reference to. Okay,
so Mr. Chakraborty, you show that on death of a license holder, his son has got no right to apply.
I can file a wrong petition before the court. There is res judicata, res sub judice are principles.
No,
I can always file. I can ask for Taj Mahal also.
You are in the High Court, not only fundamental rights, High Court
it's a legal right
jurisdiction, but can be invoked on complaint of violation of legal right also. So you show that a son whose father was running a country liquor shop or any liquor shop, on demise of his father, he has no right to apply or to get a license.
No, he cannot get a license, but that is a bar, absolute bar. Advocates rules, just for.
Forget about the advocates rules. I am coming to advocates rules. A son who is unemployed son. His father was running. His father used to run one liquor shop. Father died. Then the son has applied that you grant license in my name.
Yes,
so that I can run the same. Whether he has, your rule has permitted him to apply for or not. Or your license is so person specific that it will be cancelled on the date of the person in favor of whom it was granted. You show that it is personal.
May I try to answer?
Person specific.
May I try to answer this one? May I try to answer?
Yes.
Ask me two questions. Whether anyone can apply or not. There are certain restrictions, like if he has a criminal record.
Whether he will be eligible or not, that is another aspect. Whether he can apply or not.
No.
That means the state has recognized the right of such legal heir to apply.
Right to apply and right to consider. Two different
things.
My first will be right to apply. I will say yes.
So he has a right to apply.
And I have a right to dismiss.
Now you consider here the father of the petitioner died and he was survived by 6 or 7 legal heirs. Now, if any person died leaving behind only son and his advocate. Now, if he inherits any liquor shop, then what will be the situation?
Only one son.
Only one son.
But it has to be a.
Here you are taking that he is seeking joint license. Since there are many other legal heirs. So only one son who has been a practicing advocate. Now he has inherited the foreign liquor shop, which was being run his father on demise of his father. Now what will be the situation?
May I try to? We had given the blue book of excise.
Blue book. No book has been given.
My lord, I had
He has given the,
no, I had handed over the book on some other matters, excise rules book.
My lord, one more.
এই exercise rule উনি দিয়েছেন?
Previously, excise.
Oh,
Yes,
you have donated? Oh. এই দেখুন তো কোথায় exercise rule
My lord,
দিয়েছে? Okay, what rule you want to rely upon?
one thing I should place out. The death of my father, I was the only person who set out on behalf of all the legal heirs to issue out the joint license. It is in 2018. Kindly be taken at page number 21, my lord.
You suppress.
No, my lord, I have not. Kindly come to page.
You suppress that I am
My lord,
advocate.
I am come to page number 21, my lord.
You are not
My lord,
totally, you have not approached
My
with
lord,
clean
my
hand.
lord, kindly come to page
Ah.
number 21, my lord.
You are in court of equity also.
My lord, kindly come to page number 21, my lord. Kindly come to page number 21.
Why you suppress this fact?
I have not suppressed. That's the thing I'm saying, my lord. Page number 21, my lord. The letterhead starts out with 21 of the writ petition, my lord. Sanjeev Sarkar, advocate, my letterhead is there, my lord. The entire thing, what I've said into the letter to the excise collector.
When it was considered?
It was in 2018 I made, my lord.
You made. When your
in 2020, 2020, my lord.
2020 rejected.
In 18, I
So,
informed.
Mr. Chakraborty,
And one more thing I said.
he in his letter pad, he has given a letter.
Even I said out.
Letter pad itself reflects that he is a
My
practicing
lord,
advocate.
kindly take paragraph number 2 and 3 of that letter, my lord. Kindly take paragraph.
Okay, got it. So he disclosed this fact.
On behalf of all the legal.
So your officer is not factually correct.
My lord had
Revisit the issue and consider his pair as per the rule prevalent at the time of death of his father.
My lord, with deepest respect, kindly then allow me 1 day's time. I'll come with judgment that I have to consider extent rule, and that extent rule does not permit. I'll show that judgment. In excise matter, there's a Supreme Court judgment specifically saying at the time of consideration, the rule what is prevailing that has to be considered.
Okay, come tomorrow. Huh?
Absolutely.
Which rule will be applicable?
Whatever your lordship thinks of it.
A Supreme Court has said.
But my lord, I'll be honest, my lord, legally I can oppose.
I don't know what.
Morally, I
don't know.
Asking
I don't know whether if it is the proposition laid down by the Supreme Court that is binding upon this court. But unless a rule expressly it is public and declare that it would be operative retrospectively, no rule can be given retrospectively. You know,
that is the law. No act can be given retrospective. Otherwise,
yes. No statute.
My lord, I'm not going into. But the question is, today, my lord is sending us to consider it afresh. His issue. If the moment I consider this, the moment I start to consider this afresh, on this basis, now the prevailing rule is only 1 year can succeed, because what is happening, my lord, it is ultimately it's a revenue of the state that was getting compromised. So many infighting between the brothers and sisters, and I would also request, my lord, let the other brothers be made a party, because but there's whatever we do not know.
No.
I have to
Mr.
also
Chakraborty, you are thinking from that angle.
No, I have to.
I am requesting you. You think that you are denying the right to inherit of a person right to inherit something.
I'll come with all the judgments.
For being engaged in a legal profession. For being engaged in a legal profession.
My lord, practicing lawyer and legal license.
Where the applicable rule has empowered that you can inherit your father business as sleeping partner.
I bow down to that observation, but today,
so,
my lord, may I only say, my lord, I have to take 2 instructions. Whatever has followed.
Court will not allow you to deny that right.
No, another instruction. What is the present status? Whether it is
one person has a right to inherit his father's property, estate, everything.
I'll satisfy to this court. This is not an inheritable.
One more thing I should submit, my lord. That is infighting within the legal heirs. There is no infighting, my lord. I made an application in 2018 on behalf of all the legal heirs. All the legal, there is no way fighting.
May I only request, kindly keep this on 16th. I'll also take instruction, what is the present status of this liquor shop? It is running.
Okay, heard the learned advocate appealing for the respective party, list the matter for further.
Oblige, my lord.
You have the state response.
This is case, my lord, for non-giving the appointment, my lord, of non-official marriage officer, my lord, after being selected.
To consider the claim with sympathy and to give appointment to the post of non-official marriage officer in the vacant post or in Ghata.
An advertisement was made for appointment of non-official marriage officer. Petitioner applied for the same. Then interview was held. Petitioner was called for interview. Petitioner appeared for interview. Then he passed the interview. Then Miller District Selection Committee Miller recommended her name and forwarded it to the Judicial Department for consideration of her case for appointment. Then Miller, the Deputy Secretary Miller, your lordship kindly come up page 20, Miller. Then Miller, the Deputy Secretary directed the petitioner Miller to produce all original documents and self-declaration affidavit Miller. On that day, the petitioner appeared and produced all original documents.
Thereafter, what happened?
But till that, nothing has been done, Miller. Then Miller, petitioner submitted a representation that is still pending for consideration. Page 23, Miller.
Yes, what happened?
But, first of all, for
18.
Maybe.
Post is there, Miller.
And below
I have stated.
advertisement published on 2015. And below advertisement issued on 2015. He has made application below. And
What is the stand of the state? What is your instruction?
that we are nowadays the law department is looking after this.
So I am asking him, law secretary, to add as a party to the law secretary.
Already there, Miller.
Already, law secretary is there.
Yes, Miller.
No, Miller.
Judicial Secretary, Miller.
Judicial department is not in season now. Now the law department is in charge.
He should implement law department as a party responsible secretary. And Miller. Yes. And Miller. Now the
Law department is in charge. Now the law department is in charge of it. Previously it was
Yes.
department.
Now it's law department is in charge. Miller, in
That
view of
I
the
will-
representation, Miller, we would Miller consider it if your lordship so directs Miller, let it be Miller your lordship's order. And Miller, in strict adherence to the extant rules and recruitment policy. And then in terms of the Miller,
Yes.
in terms of the Miller available vacancy and also Miller availability of vacancy and also Miller extant rules. Extant rules.
Consider his candidature.
In terms of those Miller.
Subject
to availability, your lordship kindly
লিখুন আচ্ছা at the outset Mr. Mitro
Prevalent rules and prevailing at that point of time.
ওটা তো বলেছে, yes.
Prevalent at that.
হ্যাঁ,
Prevalent at that time.
in accordance with the applicable rule prevalent at the time of initiation of the selection process. Oh, Mr. Mitro. Yes, yes. Next. Six. এইটুকুনি করতে মতো।
On record actually is ill.
Okay, not today,
Not for this week.
not this week. Okay, not this week.
Okay, grateful, my lord.
Yes.
Seven, my lord, I am for the petitioner. And my lord, this is the affidavit of service.
My lord,
বেশি কথা বললি না, দেরি হয়ে যাচ্ছে।
my lord, my senior is Mr. Amit Sharma is engaging.
হ্যাঁ,
My senior is Mr. Amit Sharma, representing the respondent number 1. He is engaged in court number 1, and please, I am seeking for a pass.
it is your an opportunity, you place the case.
I am not aware so that.
Unless you
Short point, department,
exploit this opportunity, you will not be able to, how you will get chance? When you will get chance to open your mouth in the court? It is the opportunity, exploit it.
I am not aware.
Huh?
I am not aware the fact of.
So what you are doing? So long, you could have read it. Disburse the reward amount in favor of the petitioner being the legal.
and that.
Reward, what is along with interest?
Yes, 7.5%.
Why reward?
I'm-
What reward?
My uncle of my father,
Uh,
he was offered the reward. Thereafter, he died. My father also died. I obtained the succession certificate from the competent court regarding the reward. I have applied several times. That has not been considered. Let them consider. Kindly see annexure at page 12, page 49. And there.
What is the reward?
Reward, lordship will get it 7.5% of the amount realized. Kindly come to page
Realized from whom?
from the tax evader. My predecessor in interest gave the information to the department, income tax department, that he is the person evading the tax. And the department said that as per the circular, you will get reward. And the amount of reward that has been stated, 7.5% of the amount recovered. Subject to max.
That is one-time payment.
Yes, that has not been paid. And admittedly, the department communicated.
So your uncle's father, he should have got it.
Yes, my father's uncle. And I am the only successor, and I obtained the succession certificate. And the department's communication is that yes, we do admit that he is entitled.
Where is that admission? So I am sending the matter, learned friend. I am relegating the issue to the department.
Yes.
Whether, what will be your stand? I am not giving any direction. I am asking them that you consider whether he will be entitled or not.
Just give me 2 minutes.
2 minutes.
1 minute. Just
Okay, pass over. So,
pass me. Lordship, kindly I will look into annexures at page 51, 52, 53. The department is saying that it is under consideration. But when that period will end, consideration period, can you see page 51? Copy forwarded.
Or I am making it not today, come tomorrow. Come tomorrow?
Monday.
Okay, Monday.
And
Yes.
the affidavit of service may be kept with the record.
Whether any order is required to be recorded?
As your lordship, since his appearance may be recorded.
Your?
As your lordship. Maybe.
Heard the learned advocate appearing for the respective party leaves the matter for further consideration on 14th. Yes.
Got it.
Next.
8.
8. 8 or not? 8টা দিন তো আসেনি কেন? বলবে না নাকি? দিদি বুঝতে পেরেছেন? হ্যাঁ, 9 তো দেখি। 9. Yes.
And I am appealing for the petition in this matter.
I appeal with the state respondent.
Rasif, I have made an application before the subdivisional officer for giving me the scheduled caste certificate, scheduled tribe certificate, because I am the Mahato, but it was not taken any steps by the subdivisional officer till date. Previously, I have also made another application previously, which was stated only the rejection, nothing else, nothing but.
They have rejected.
Only rejected, application rejected. Kindly come to page 26. Later on, I have
24. 24 is a rejection.
24 rejection. 26 is the notification.
Acknowledged slip.
Only says the application rejected. No grounds has been stated. Later on, I have got a notification from the government of West Bengal, District Manager Dokhin Dinajpur, page 25.
Yes.
It is stated that the issue of processing issue, last paragraph, to processing or issue of scheduled type certificate to person having surname Mahato hereby kept in abeyance. If I am a student, I have not getting any chance to get the benefit of the scheduled type certificate. Kindly direct the secretary
Yes, what is the?
Page 25, my lord, that is.
Yes, I am 25.
That is the only application rejected. That is, my lord, passed on 14th August 2019. And thereafter, he moved a writ petition before this honorable court.
It was rejected by the honorable court that I have not annexed the application.
Page 27 is the.
For technical reason.
Yes, my lord. There is the application for caste certificate is not on record. That is the matter is dismissed, disposed of. And thereafter, my lord, he applied, I find, page 28. My lord, on 27th August 2021, my lord, he applied through online for caste certificate. And
yes,
it was not taken into consideration.
Whether you are a Kurmi community.
I am a Mahato. And my father, my grandfather also got the certificate of scheduled type certificate.
But I find, my lord,
that pass reason order.
Yes, sir. That
he has a right to know the reason why his pair for grant of type has not been used. Okay. So if his pair is rejected, you will communicate the reason order. Yes? Or if it is not rejected, you afford an opportunity of hearing or pass a reason order. Huh?
I find, my lord, the page 25, the learned friend, which is annexed.
No, it is not addressed to him.
Yes, this is actually.
It is not addressed to him. You have somehow collected it.
Yes.
The citing inaction on the part of the concerned respondents in
Concerning on the original side. Original side matter.
I think 14, the last item. That is for hearing. Maybe your lordship may not be able to take it up today. My client is suffering from cancer. My client is suffering from cancer. If your lordship kindly fixes a date and hears this matter out, I'll give notice to the other side.
Okay. Okay, you ask your juniors to stay. If it is not reached today, then it will be placed at the top. At least fairly at the top.
Today?
Today, if it is reached today, it is okay.
The other side may not be ready for it. That's why I was telling your lordship keeps it next
So,
week.
so when I will seek next, then it would be upgraded.
Only that.
Yes. Okay, so.
Item number 1.
Oh.
But I am appealing for the petitioner. But this is my application for contempt of violation of your lordship's order, which your lordship will get at page 20. Kindly see the operative portion at page 24. This is on the change of rule of game, where in the midst of a promotional process, my lord, the incorporation has been made by a subsequent notification granting marks on the basis of the length of service.
আচ্ছা এই লিখুন তো লিখুন মিস্টার দত্ত মিস্টার বসু অ্যাডভোকেট পেন্টিং petition is made returnable or not? Tomorrow, কালকে তো হ্যাঁ ঠিক আছে Yes.
This is that matter, encashment of my lord, letter of credit, my lord. Last week, Mr. Thakkar was arguing before your lordship.
Oh,
letter of credit, my lord.
Yes, letter of credit, yes.
I am being led by Mr. Rupak Roja.
My lord, Mr. Thakkar is on his way, my lord, from that building, my lord. If your lordship kindly passes it over for 5-10 minutes, my lord. Is coming, my lord.
Whether you are ready?
My lord, let us complete our argument today, my lord. We want to.
Lordship, thereafter we start.
We have to show 1 or 2 judgments, my lord. Then our submissions will be concluded, my lord.
Okay, let him come pass over.
Pass over. Great.
My lord grants a short passover. My counsel is on the way. Short passover.
The other side is also not here. No, not your matter.
No, your lordship, I don't see them.
So I am making a note today. That would be better. You are not also ready.
Then your lordship will kindly
Not today.
Kindly fix it on the next date.
Four.
Lordship, in this matter, appear for the respondent bank, my lord. My lord, there was a direction for filing our affidavit in opposition, my lord. But my lord, since we are out of time, my lord, I am seeking your lordship's leave to file our opposition, my lord. My learned friend is not here, my lord. If your lordship accepted my opposition, my lord.
Whether they are interested, set aside the rescind the order or passed by the general manager Solle Zone UCO Bank and the order of appellate authority and the order of review. Whether it is disciplinary proceeding.
Yes, my lord. There is a dismissal case, my lord.
Dismissal of service. Okay, the affidavit in opposition filed on behalf of the respondent. You are repenting all the respondents?
Yes, ma'am.
Okay, respondent is taken off record. The petitioner is unrepresented. देखिए আসবে নাকি হ্যাঁ এখন আসছে তো
Item number 4 for the petition.
So petitioner unrepented কেটে দেবেন so you filed
Repeated chance was given to the respondent. I don't know. No copy of the affidavit in opposition has been served.
আর ওইখানটা থেকে ধরুন taken on record করেছেন a copy of that affidavit in opposition has been handed over to the learned advocate.
Item number 5. 5 I am for the petitioner. হ্যাঁ দিয়ে দিচ্ছি
Who is your other side?
I don't. Last time appeared. They appeared.
Toiles Mishra, advocate for UCO Bank. What do you want? It is also disciplinary proceedings.
Disciplinary proceedings.
Dismissal.
Dismissal.
What is the allegation?
Allegation, my lord, indulging some customers, my lord, for getting loan. All are UCO Bank manager.
You allegedly you took bribe to secure loan from them.
No.
I do not say you have done it, but it is alleged. It was alleged. Yes. So inquiry officer found that the charge has been proved.
Yes.
Disciplinary authority agreed with this finding.
Order of dismissal, preferred an appeal, affirm the order of the dismissal. That yes, sir.
But the direction for
affidavit has already been exchanged in the matter.
Affidavit exchange. Okay. Toiles Mishra.
May I give another notice?
Yes.
Yes.
Having heard the learned advocate appealing for the respective parties and
Petitioner, Your Lordship, I'm led by Mr. Obratosh Mujumdar. He's on his legs, Your Lordship. I'm praying for not today.
Okay, not today.
Number 7.
I have for the petition in this matter, my lord.
Yes.
But
Is
this is
your
a
other
case of
side?
my
Yes. First matter where both sides are present.
Well, this is a case. Here, my lord, the petitioner was, my lord, an employee of, my lord, Eastern Coalfield Limited.
But I appear for the Eastern Coalfields Limited, my lord. My learned friend
It
appears
is
for the
also
Coal India-
disciplinary proceedings.
Disciplinary proceedings.
Item number 5, my lord. My lord, I beg to appear on behalf of Coal India, that is 1, 2, 3. May I file my affidavit in opposition?
Keep it filed on the date. Have you served upon the other side? Mr. Chatterjee just left.
No. Even this matter.
No,
The matter
this
which
is
is right, taking out right now.
Now, if it is opposition, now you are filing.
Yes, madam. This is the first time which is being taken
Have you
out.
served upon them? They have filed reply. Yes. তাহলে আপনি লিখে দিতে এফিডেভিট why two copies?
Because affidavit in opposition has been filed by the ACL as well as Coal India. So, my lord,
1, 2, 3 is Coal India, and the rest are Eastern Coalfield.
Eastern Coalfield.
Oh,
so both reply, my lord, has been affirmed and filed.
I am also, my lord, filing my affidavit in opposition.
okay. The affidavit exchanged by the party. Affidavits exchanged by the parties are taken on record. যা দিয়েছে নিয়ে নিন। বুঝতে পেরেছেন? Yes. Yes, start.
My lord. Here, my lord. Point is, my
Disciplinary
lord,
proceedings, dismissal.
dismissal from service.
Dismissal from service. What is the allegation?
Allegation is, my lord, the petitioner in course of his, my lord, duty, he was the executive of a particular area of Eastern Coalfield Limited, though his appointing authority is Coal India Limited. He is the officer of the Coal India Limited, but, my lord, the officers are, my lord, posted various subsidiaries.
Yes.
Now he was posted at Eastern Coalfield Limited in a particular colliery as manager. Now, at that time, my lord, there was an allegation, my lord, that he has, my lord, received a bribe of 10,000 rupees from a person, and, my lord, the CBI has, my lord,
Got red-handed.
got red-handed, and on the basis of that, my lord, the charge sheet was issued, and, my lord, the disciplinary proceedings was continued, and final order of punishment has been, my lord, passed. Against this order, I preferred appeal before the appellate authority. Appellate authority also, my lord, confirmed the order. Then, my lord, the criminal proceedings was also going on before the CBI court. Now, the CBI court, my lord, finally acquitted, my lord, the petitioner. Now, my lord, after the acquittal, I also, my lord, file a review application before them, so that the punishment order can be reviewed. So they kept mum over the issue, and I again, my lord, move before this honorable court for consideration of that representation of review application, and consider and review also dismissed. Now, thereafter, my lord, I am challenging the 3 orders, my lord: removal, then appeal order, as well as, my lord, order passed in the review jurisdiction. Now, if you lordships kindly come, the charge sheet, my lord. Page, my lord, 39. This is the charge memo dated 19th July 2014.
Yes.
Now, in the charge memo, if your lordships kindly come,
On
page
such and such accepted bribe of such and such from one Sagar Maji, working as mining siddhar, for deputing him on light duty. Yes. Only one charge.
only one charge.
Your lordship, kindly turn to the next page, article of charge. That's not only.
My lord, page 40.
The article of charges is in the next page.
My lord, page 40. Article of charges.
Yes, page 40.
40.
40, I have read.
Well, here is very important, my lord. If you lordships kindly see the, my lord, opening word of, my lord.
What evidence PW1 gave? Sagar Maji deposed?
No.
Sagar Maji did not depose.
Now, my lord, kindly come.
So whether there was any eyewitness?
No. I will satisfy to your lordship. There are volume of papers, my lord. If you lordships kindly come the page 40. There was a complaint made by the Sagar Maji, but there was a CBI investigation. It has been revealed during the CBI investigation, Sri Prabhat Kumar Jha, senior manager such and such Sodhpur area in the office of the manager Narsamudra Colliery, had demanded, agreed to accept an accepted bribe of rupees 10,000 only on such and such from Sri Sagar Maji, working as mining sorter Narsamudra Colliery, for deputing him on light duty in the underground mines on medical ground. In spite of the several requests made by the complainant on medical grounds, Sri Prabhat Kumar Jha such and such changed the duty point of the complainant and harassed him by giving duty at the fastest place of the mines. Sri Jha called upon to complaint number such and such and demanded 20,000 in order to get him relief from tough duties, and further threatened that if he fails to pay 10,000 in first installment, he will never be given the light duty. That was the allegation on the basis of the investigation conducted by the CBI authority. Now, there was no complaint made by the Sagar Maji before the Eastern Coalfield Limited. No complaint. Only on the basis of the pendency of the CBI investigation, I have been charged. Now, I file, my lord.
So he lodged complaint with the jurisdictional police station?
Before the CBI.
CBI.
Directly.
Yes.
As it is alleged, but the trial court conducting the trial did not believe that.
Yes.
Now, if you lordships kindly see my reply as page 44.
Reply mere denial.
Denied.
Denial.
Now,
that I have not done it, I have not accepted
yes.
it.
Now, page 47, my lord, the inquiry
47.
report.
Page 47, inquiry report.
Inquiry
Yes.
report. Concluding part is, my lord, 45.
Forty-seven, then how 45?
47 to 79.
Yes, 79.
79.
Concluding part 79.
79. From the aforesaid discussion regarding this department inquiry against me, I think, no, this is, my lord, ki likhecho pagination gulo. This is my statement.
Yes.
Page 72, my lord. Page 72 is the, my lord, not 79, page 72.
Yes.
Thus, it can be concluded that Sri Jha has committed misconduct, such and such, such and such, such and such. That was the findings of the inquiry officer. Print out now, Neta. Are ki polvo. Now, my lord, kindly come, page 80.
Oh. You are trapped.
Yes.
There was a trap witness. The amount, the currency note were recovered from your possession.
Here, I was in underground. At the relevant point of time, I being the manager, I was in underground.
Apart from it was seized.
Your coat, his coat was hanging in his office. This gentleman, my lord, put that amount in the pocket. There is no eyewitness. I am coming to that, my lord. This is a very interesting matter, my lord.
Yes.
Now, kindly come page 80, my lord.
Page 80.
80.
Disciplinary authorities order.
Authorities order. Final part is that, my lord, 93. জাজমেন্ট গুলো করেছে সুপ্রিম কোর্টের জাজমেন্ট ওইটা আর বাকিগুলো
Yes.
ফাইলটা আনতে বলো তাহলেই হয়ে যাবে। Now, my lord, kindly see, do hereby impose the penalty of dismissal from service with immediate effect of on Sri Prabhat Kumar Jha, such and such, such and such, such and such, and presently posted at Safety Department, ECL headquarters. Then against this order, my lord, I preferred, my lord, appeal before the appellate authority, that is at page 94. Now, my lord, further representation, I am not going into that. Then page 122, there was a direction passed by this honorable court for disposal of the appeal preferred by writ petitioner. Page 122. Now, thereafter, my lord, the appellate authority passed the order of appeal. Page 131. ঠিক আছে यहाँ से निकलो না এটা নয় পয়েন্ট করে কিছু চলো
There was to trap witnesses along with the complaint. You demanded certain amount from the complainant.
Hello.
Then the one of the trap witness, namely Irfan Alam, he says that he has witnessed you to take the money. The currency note, some solution was applied. Thereafter, it was found your hand was how it is done. Then one pink color came.
Yes.
That will be proof that you touch or you accepted the amount. Subsequently, you stated that no, it was recovered from your pocket. The one coat was kept in your office room, and from that pocket it was recovered. It is your case.
Yes.
Yes, proceed.
Now, page 132.
132.
My lord. This is the order, my lord, during pendency of the disciplinary proceedings. I came before this Honorable High Court for staying of, my lord, the disciplinary proceedings during pendency of the criminal proceedings so that the defense
cannot be disclosed.
Now the single bench did not interfere. Division bench, page, my lord, 135.
Yes.
My lord, directed the authority, my lord, to, without entering into the merits of the case, we modified the judgment that the ordering portion passed by the Honorable Single Judge to the effect of the disciplinary proceeding may pass appropriate order in accordance with the law. After affording an opportunity hearing to the appellant within a period of fortnight, the petitioner is directed to appear before the disciplinary authority such and such, along with such and such. So subsequently, my lord, the disciplinary authority, for that ground, for 1 year, they stayed the disciplinary proceedings. Thereafter, again, my lord, since by 1 year, my lord, the criminal case was not concluded, again they have started, my lord, the disciplinary proceedings. Now, if your lordships kindly come, the page 150, my lord.
Yes.
This is the ordering portion of the authority for staying of the disciplinary proceedings, though it is not at this stage necessary, my lord, but still, my lord, it is annexed in the writ application, my lord, so it's my duty to place, my lord.
Yes.
Now, my lord, CBI has filed the charge sheet, page 151.
Okay, ultimately in criminal court, they could not prove their case.
Yes.
Okay. The prosecution failed to prove their case. You have been acquitted.
Acquitted.
Okay, use the word honorably acquitted. Okay.
No, it is acquitted means, my lord, honorably.
Yes, you have been acquitted.
Now, page 160, if your lordships kindly come.
Yes.
This is the witnesses in the, my lord, criminal court.
Criminal court, Mr. Maji deposed.
No.
In criminal court also, Mr. Maji did not depose. That two tap witness deposed.
My lord?
Two tap witness, one Irfan and such and such.
Yes.
There are two tap witness and the complainant. You are tapped in a place. So at that place, allegedly the incident occurred in presence of 3 persons, complainant and two tap witness. They deposed in criminal proceedings.
No. I am coming, my lord. Page 160, if your lordships kindly come.
160, yes, yes. Irfan deposed.
Now, page 42 of the, my lord, first volume.
Yes.
My lord, may I read from either one to compare whether both are same or not? সাগর মাঝি, সুমিত দাশগুপ্ত, শরদেন্দু গাঙ্গুলি, সোমনাথ বিশ্বাস, রবিরঞ্জন প্রসাদ, ইরফান আলম, স্বপন কুমার পাল, জি
So
রাম.
set of witness are also same. Same witness,
Same
yes.
witnesses.
The judgment of Ram such and such.
Now, Ramlal.
Ramlal
and Ram Pratap and Maharana Pratap.
Maharana Pratap.
Maharana Pratap is the recent judgment of the Honorable Supreme Court. Now, if your lordships kindly come, the judgment of the criminal court, my lord. My lord, I have typed out the fresh copy, if your lordships allow, my lord. Type copy করেছি fresh করে.
Yes.
My lord, here the judgment is, my lord, required to be read into, my lord, as a whole. তো এখানে ক্রিমিনাল কোডটা কত নম্বর পেজে আছে? হ্যাঁ, পেজ 176. এখানে কোথায় এখানে মার্ক করা আছে? 176. If your lordship kindly come page 176, though it is typed, in the typed I have not highlighted.
Internal page, here you say.
Internal page 10.
10, yes.
10 of the main judgment from the writ application, my lord. I have given type copy. If necessary, your lordships may use type copy.
Okay, I am using type copy, yes.
Type copy. Then, my lord, I have to find out. আরে বাবা 10 এর 8 আর এটা এখানে কোথায় আছে তাহলে এটার সঙ্গে তোমার কম্পেয়ার করতে হবে তাহলে নাও my lord kindly come. Thus the shadow witnesses, it is my lord from 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. 13 line from top. Thus the shadow witnesses failed to become a eyewitness of demand making, giving and accepting of alleged bribe money.
Yes.
And he admits that in his cross-examination that he did not see what happened inside the chamber of the accused person. Next page.
Yes.
Now kindly come next page. This also, my lord. কোনখানে আছে এটা? Kindly in the middle of this, my lord, judgment of the criminal court. Thus, we have evidence from the prosecution witness. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 line from bottom of page number 11. Thus, we have evidence from the prosecution witness that the accused person was never in a position to dictate his whims upon the complainant by making demand of bribe on the very day of the occurrence. Neither he was ever in a position to accept the bribe in his own volitions in absence of CBI officials.
Yes.
Next page, page 12. As to why I am showing to your lordship the age of the person, it is very relevant. Because in Eastern Coalfield Limited or Coal India Limited, there is a scheme. The persons either, my lord, die in hardness, his survivor will get the employment, or if he become incapacitated in course of his employment, either one from the family will get the employment. Now, my lord, kindly read this part, my lord. 1, 2, 3, 4, 5, 6, 7, 8. 8 line from top. Firstly, the complainant ascribes himself as a man of 58 years in the FIR, while from the exhibit 4, collectively it appears that the age of the complainant was 59 years 5 months, being calculated from the date of birth of the complainant as 1st July 1954, and thus left only 7 months service. We have evidence that there is a trend and norm in the ECL that the employees in the closing days declared themselves as sick to work, and on that ground, one of the years of the employee gets service. Now, next page. Paragraph page 13. The opening word of this, my lord, page 13. Demand bribe from the complainant goes unproved. PW6. deposed that as per the register produced and exhibited in court, exhibit number such and such, it appears that the complainant was in duty on such and such day from 8 AM to 4:30 PM. And there is no fax facility underground, in the underground. Now, if the FIR is carefully looked into, at it appears topmost part that can be seen that the same was faxed to CBI at 4:30 PM on 6/11/2013. Even, my lord, the complainant was also not, my lord, faxed this, my lord, complaint, because he was underground at the relevant point of time.
Complainant.
Yes.
Yes.
Now, next page, page 14. All these, my lord, kindly see 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 line from, my lord, top of page 14. All this, the FIR, make the FIR itself of the case of the questionable authenticity, especially in absence of complainant's evidence. Overall, the defense case as it emanates from the cross-examination of the PWs, and also few part of the examination in chief of the sum of them gains considerable credibility. Now at the bottom, my lord, 1, 2, 3, 4, 5, 6 line from bottom, the obvious. This line from bottom, my lord, the obvious presumption arises therefrom is that the money, the same page, my lord, page 14.
Yes.
The 1, 2, 3, 4, 5, 6.
Got it. The obvious presumption arises
therefrom is that the money was sought to be forcibly inserted in the pocket, or it was forcibly dragged out against the consent of the accused person. But from the CBI officials, we find no evidence that the accused person did not cooperate them in causing the recovery of the such and such tainted GC notes from his trouser pocket and advance any physical resistance while causing the recovery. Now page 17, my lord.
Page 17.
My lord.
Yes.
In absence of his evidence, it will be very impractical to rely on the hearsay evidence or trained witnesses and assumption evidence of the CBI personnel. Sufficient evidence has been adduced by the defense through the cross-examinations of the PWs that the accused person was never in a position to assign lighter job than what he was allotted for the de facto complainant. Because I was not in a position, my lord, to allot the light duty. That was the, my lord, allegation that on the, my lord, assurance of light duty to assign the lighter job than what he allotted for the de facto complainant. Next page, my lord. Page 18. Compare করাবো কি আসেনি কি আসেনি সেই কারণে তাদের কোশ্চেন করব
Yes, yes.
Now, page 18, my lord, kindly see. Second paragraph. Furthermore, a specimen individual voice recording of the complainant and the accused persons were not adduced in evidence. The independent witnesses have expressed their utter ignorance about the familiarity of the voices of the voices personally. PW 15 deposed that the voice recordings were not clearly audible. PW 19 has deposed in his examination in chief that after entering the chamber of the accused person, the complainant came out with a couple of minutes and the voice recorder given to the complainant was switched on when they started for the PO from ISCO guest house. In this context, if the report of the forensics expert is looked into, it would be found that the two clips of conversation he was given with 2 hours 36 minutes and 1 hour 33 minutes long, but eventually the complainant was asked to switch the recorder off immediately after they came out of the chamber of the accused person. Now page 19, my lord. কতটা?
Yes.
Now this may be safely be sum up in holding that this court is constrained from the raising presumption of guilt of the accused persons as alleged under section 20 of the Prevention of Corruption Act 1988 and the defense versions of the case in a form of a second hypothesis from the same facts is strong rebuttable thereto, but it means rea of the accused persons for making the demand. Both were not proved beyond reasonable doubt and the prosecution is legally bound to do. There is no real evidence of demand of bribe by the accused persons either on 6/11/2013 or 7/11/2013, nor the acceptance of the bribe was witnessed by any of the witnesses. The IO submitting the charge sheet never seems to have verified the facts made out by the TLO. The voice recording evidence were not sealed at the spot, but only were kept on an envelope altogether without any identification marks on those files. The PW 16 stated that they were sealed at the spot of seizure. Okay.
Yes. So your contention is that decision is based on no evidence, perverse.
Based on no evidence,
perverse.
And my lord,
and the criminal acquittal from criminal court.
Acquittal from criminal court.
Ramlal judgment.
Ramlal and Rana Pratap, I will show to your lordships. And my lord, the entire disciplinary proceedings was based on the criminal case, and there was no appeal against this order.
Yes, evidence are same set of witnesses. Or disciplinary proceedings and criminal
proceedings,
Yes,
and there was no complaint. There was no complaint before the authority, before the ECL authority by the complainant that they have started the disciplinary proceedings independently, irrespective of the fact of the pendency of the criminal proceedings. Here, my lord, opening word in the charge sheet, your lordship will find that based on the initiation of the criminal proceedings by the CBI, the charge sheet has been issued. So when there is no criminal case, so there is no, my lord, question of any punishment imposed by them.
Yes.
Now, my lord. Kindly come page, my lord, 215. Okay. It's a correct statement.
Yes.
Page 215. This is the statement of Irfan. This is the statement of Irfan Alam. 1, 2, 3, 4. Four, my lord, paragraph from top. You also got it, my lord, page 215, my lord.
Yes, yes.
My lord, regarding post trap and trap lying memorandum, I did not see what happened. Page 215.
Of
Well, now, my lord,
volume 2.
Volume 2, my lord.
Yeah, 215, some question and answer.
Question and answer. Now, my lord, this is a statement of
Regarding post. Yes, yes.
Yes.
Got it.
The regarding post trap and trap lying memorandum, I did not see what happened inside the chamber of Sri P.K. Jha, the then manager. I only saw that Sri Jha was coming out of his chamber, followed by Sagar Maji, and was about to get into a car. At this point of time, Sri Sagar Maji gave a prefix signal, which was also followed by me, and the CBI official instantly arrived on the spot and caught Sri Jha, who was taken back to his office chamber. The remaining part of the memorandum, so far as is concerned to me, are admitted. So he also, my lord, not present inside the chamber. Now, my lord, another statement. Now, if your lordships kindly come, affidavit in reply.
Then,
my lord, affirmed on April 10th, 2024. এখনই দিলাম এই মাত্র।
Yes.
Page 7, my lord.
Yes.
My lord, I have compared what statement they have made. Now, page 8, my lord, kindly come.
Yes.
This is the statement of Joyce Chandra Rai, who was, my lord, the agent of the, my lord, colliery, that is one rank above to the writ petitioner. Now, his statement, my lord, not against the writ petitioner, though he was projected as prosecution witness in the both the proceedings. Page 11, his final version. He was the agent, means, my lord, one rank above to the writ petitioner, my lord. I did not receive any complaint regarding harassment of late Sri Sagar Maji. He was projected as prosecution witness, but he never my lord, uttered anything about the, my lord, credibility or anything against the, my lord, the writ petitioner. Now, my lord, Bijon Kumar Biswas. He is also, my lord, projected as prosecution witness. I have compared everything, my lord. Kindly see what he has said at page 13. Right hand side. I tried to free Sri Jha because at that time the CBI officials were slapping to my client. So this gentleman was passing thereby, and my lord, my lord, tried to, my lord, he does not understand who are these persons. Those who are, my lord, caught there, my lord, officer, and slapping inside in front of the, my lord, office of the manager. Now, my lord, kindly see, I tried to free Sri Jha, accused, from the clutches of those unidentified persons. Mankeshwar Prasad, medical dresser, also tried to set free the accused persons with me. Those two officials also threatened me, that means the CBI officials, and Mr. Prasad, to go away from there, otherwise we too will be arrested. Accordingly, we too went to a site nearby, and those officers took the accused to the manager's office. Even all these are prosecution witness. Prosecution witness also said in favor of the writ petitioner in the both proceedings, not only in the criminal proceedings. Now, my lord, before, my lord, এটা Sumit Dasgupta আসেনি. Now, kindly come page 14, my lord.
Yes, got it. I have got it.
Yes.
Based on no evidence.
Yes.
And something. Then
yes.
Now give the judgment of Mamla. Yes.
Well, this is the latest judgment of the Honorable Supreme Court.
Yes. Maharana Pratap. See.
Maharana Pratap.
Yes.
Citation 2025 SCC online SC 890.
Yes.
Of Justice Dotto's judgment. Paragraph 13, if your lordships kindly come.
Paragraph 30.
13.
13.
The decision in Swati Singh versus such and such was relied upon by this single judge to hold that the charges were vague, indefinite. This is another aspect. So, paragraph 14, my lord, is important. The single judge further noted that the charges in the criminal proceedings against the appellant and the evidence prescribed by the prosecutions to substantiate the same were
largely identical. Yes.
Largely identical. To those in the departmental process.
Yes.
Placing reliance on the decision in a GM tank such and such, the single judge concluded that the charges number 1 could not have been held to be proved by the disciplinary authority, since the respondent number 5, 4, and 2 failed to prove the reasoning distinct from that of the relevant session judge who had acquitted the appellants of the charges. The single judge further observed that it was not open to the respondents to reopen the charge number 2 in a subsequent departmental proceedings, as the matter had already been concluded in 1976 and the appellant visited the punishment. Regarding charge number 3 and 4, the single judge found them self-explanatory. Nothing that the appellant's arrest on such and such and the subsequent detention in the police lockup prevented him from resuming his duties and notifying the CID headquarters about his arrest. Now, paragraph 25.
Yes.
Analysis and reasoning. The issues for determination that emerge for decisions are whether due process was followed in dismissing the appellant from service and whether his dismissal from service is justified on the facts and circumstances that have unfolded before us. Whether in light of the facts and evidence, witness and circumstances of the case, the charges in the criminal proceedings are substantially identical to those in the departmental proceedings, such that an acquittal in the criminal case would render the findings of the disciplinary proceedings vulnerable. Whether the impugned judgment which allows the appeal of the respondents and dismiss the petition of the appellant deserves to be upheld. That was the issue before the Honorable Supreme Court. Now, page 47, paragraph 47,
issue number 2.
issue number 2.
Yes. Ramlal liye,
Yes.
yes, it is the proposition. It is well settled when the charges, evidence, witness, and circumstances in both departmental inquiry and criminal proceedings are identical and substantially similar. Situation assume a different context. So charge is to charge, evidence, witness, and circumstances of both the proceedings are to be same and substantially identical.
Here also, my lord,
Then the ratio of Ramlal can be applied.
here also, my lord, not only same, based on the criminal proceeding, the charge sheet was
Yes,
issued.
yes.
Now, paragraph 35, possibly I have skipped, my lord. Paragraph 35. No, this is another issue. For my lord, vague charges, I am not dealing that.
Same, yeah.
Same.
I think that's all from your part.
Now,
And
another
anything?
judgment, my lord, the Ramlal.
Ramlal, give Ramlal. Yes, Ramlal. Same proposition, yes.
Para 9, my lord, kindly see.
Para 9.
The following two questions arise for consideration: whether the dismissal of the appellant from service pursuant to the department inquiry was justified. On the facts of the case, what is the effect of the acquittal ordered by the appellate judge in a criminal trial on the order of dismissal passed in the departmental inquiry?
Yes.
That was the issue. Now 9, paragraph 28.
Yes.
Paragraph 28, just above the paragraph 28, if your lordships kindly come. 1, 2, however, 1, 2, 3, 4, 5, 6 line from the bottom of above the just the paragraph 27. However, what are supposed to see is the substance of the judgment. A reading of the entire judgment clearly indicates that the appellant was acquitted after full consideration of the prosecution evidence and after noticing that the prosecution has miserably failed to prove the charges. Now, paragraph 28, expression like benefit of doubt and honorable acquitted used in the judgments are not to be understood as a magic incantations. A court of law will not be carried away by the mere use of such terminology. In the present case, a appellate judge has recorded that the exhibit number 3, the original mark sheet carries such and such. So that was the fact. So I am not going into that. Now, paragraph 30, my lord. We are additionally satisfied that in teeth of the findings of the appellate judge, the disciplinary proceedings and the orders passed thereon cannot be allowed to stand. The charges were not just similar but identical, and the evidence, witnesses, and circumstances were all the same. This is a case where, in exercise of our discretion, we quash the order of the disciplinary authority and appellate authority, as allowing them to stand will be unjust, unfair, and oppressive.
Yes.
Now, the last paragraph, paragraph 33. In view of the above, we declare that the order of termination dated such and such, order of appellate authority dated such and such, and an order of refusing to reconsider and review of the penalty respectively. Here also 3 orders I have challenged, same.
Same.
So order of
are quashed, set aside.
Set aside, reinstatement with 50% back wages has been allowed by the Honorable Supreme Court.
50%.
50%.
Okay. Yes.
My lord, it is fixed on the next date, so we will come.
No, why you shouldn't?
But we have to.
No, so many times. I have 700 matters and hearing. Only 2 points. The decision is based on no evidence. Okay, decision is to not.
Based on no
I am saying, what is needs to be proved
Yes.
Mere recovery of amount is not suffice, will not suffice. Here allegation is that he has demanded right. So demand acceptance, and why demanded? That I shall do something for you, and he has given money. So that part is to be proved, that the person concerned has the authority or power or capacity to do such favor for him. Okay. If I say, give me time, I shall secure your chance in the Indian cricket team. You have to see whether I have a capability. I am not a selector, nothing. So I have no capability to place any person in the Indian cricket team.
That's also a crime, my lord. That's also a crime.
Yes.
I bow down to your lordship, my lord. That's also a crime.
We have
That's
to
also
prove
come
that.
within the folds.
So that evidence is lacking.
I have
To speak
my lord,
the truth, as he says.
his case.
Now the question comes that yes, the Ramlal judgments and Maharana Pratap.
How far they are
judge.
applicable in this case? How far they are
Yes,
applicable?
yes.
My lord, we
You
want
know
some-
better that. You have done.
Yes. Yes.
That I have filed my opposition. In my opposition, I have indicated what
Yes.
nature of argument our will be. The first will be, my lord, I will argue on the point of even if I have
Yes.
not gone through those two judgments, my lord, any charges are same, everything is same. Whether capital in criminal proceeding will have any bearing to a disciplinary proceedings for the simple reason because manner of proving the charges in both the cases are not same.
Yes, it is the address.
One is absolute.
One is beyond reasonable doubt, another is preponderance of probability. Everything has been discussed. Okay.
We have to peruse those two judgments. To be honest with my lord, I personally have not perused those two judgments, Ramlal as well as Maharana Pratap. So, my lord, this is a disciplinary proceeding matter.
And this
Account every
piecemeal hearing, the simple matter, piecemeal.
dispose of the application which they have.
Huh?
They have filed an application also that is carried.
That would be disposed of along with the writ petition.
That I have filed for my early hearing.
You should have get prepared and come. So come in the next week.
Yes.
Next Thursday itself.
Huh?
Next Thursday.
Next Thursday. এখনই বসে দেখছি স্যার
মানে
the decision is perverse based on no evidence and Amlal judgments he will bring.
Already knows what trying to rely upon judgment. That principle which has been will can be said to be perverse in a disciplinary proceeding. The 8 points, my lord knows that judgment then it has been stipulated 8 points only on satisfaction of those 8 points. A decision in a disciplinary proceeding can be declared to be a whether those conditions are satisfied in this petition, that will have to satisfy. Yes, all the conditions which are to be followed have been followed. Yes, it merits no interference from us.
Yes, so your argument concluded, you give that judgment. That would be dealt with. Yes, you have made good argument. Yes.
No argument has been made. I'm just.
Yes.
It is the submission of Mr. Ghosh. Probably you will contradict us him that his submission is not justified. So there cannot be any valid reason to accept the same. Yes, you have every right to contradict. He will do it. It is his claim. Okay, but do it Thursday.
Then very well, my lord. Very well. I will skip
Uh,
that matter. Very well, my lord.
Yes, yes.
That's my lord.
Okay, so I heard the learned advocate appealing for the respective party, list the matter for further consideration.
Hard, my lord. Substantially, hearing has already been made. Kindly make it.
That is nothing we will know.
My lord, sometime, my lord, our
Will
experience
not
goes,
be
my lord,
changed.
any time, any day, anything can be happen. So since your lordship has had, my lord, wastage judicial time.
I can decide against you also.
No, I don't mind, my lord. I don't mind, my lord.
I have not made
Yes,
my.
no,
I am making an effort so that
yes, my
I
lord.
could have concluded the
My
hearing
duty is
today.
My duty is to place the case and to finish the matter, my lord.
Yes, don't say that
No,
things that I have made up my
not
mind.
for that reason, my lord. Not for
I
that.
can dismiss the petition also.
Yes, my lord.
Yes.
Well, kindly, my lord, beg it hard in part.
No, yeah.
Well, kindly, my lord. On joint pair, my lord.
No, he is making you. You are forcing him to nod his head.
Absolutely the discretion of the court.
Well, kindly, my lord, make it
I have
hard.
nothing to say.
Well, kindly, my lord, make it hard.
लिखे दिन है कि ये as jointly paid by the parties and
Lordship, I am appearing for the state respondent led by Mr. Shantanu Kumar Mitra.
This matter pertains to an endeavor by the respondent corporation to make me retire prematurely. But I joined, my date of birth is of July,
Lordship, I am for the
21st January
Respondent Transport
1967.
Corporation.
That
I
has
have a
been
prayer,
made
my
correct.
Lordship.
date of birth in terms of the decision of the board of directors is not done as yet, and to record the 2nd January in place of such and such.
There was a previous round of litigation before the coordinate bench. An order was passed in the meantime.
Most probably he will take time.
My Lordship, I am for the Respondent Transport Corporation for the item number 8, 9, 10, and 11 and 13. My Lordship, actually, my senior Debrina Chattoraj had an operation on 6th July, so I'm praying for 4 weeks' time, my Lordship.
4 weeks' time?
But the whole difficulty lies in one thing. Kindly see the GA application.
She had an operation,
I
my
do
Lord.
not oppose to such things. But at 9, 10, 11, I have got nothing.
Your senior, what happened to him?
She had an operation.
Oh.
Well, let me
So
kindly
on
see
this
the GA
medical
application.
ground, I'm praying for.
9, 10, 11, that can be adjourned. So far as 8 is concerned, there is some priority may be given because the person is going to be prematurely retired, superannuated, and notification has been issued by the West Bengal Transport Corporation. Kindly see.
When he's going to retire?
But kindly see the GA application once. The date of retirement has been given as 30th September 2025. Now, my date of birth has been, what has been mentioned in my original application form, they have lost it. Police verification report, they have lost it. Now they say that your date of birth is not 1967, it will be 1965. And they want to make me kindly see page 8. Page 7, page 7 is the
Ajay Kumar Singh.
Ajay Kumar
Date
Singh,
of birth is 23rd February 1966. That means he will retire in the month of February
No, no, no.
February 26.
No, my lord.
Next year.
My lord, may kindly see the notification.
Your name is Ajit Kumar Singh.
Ajay Kumar Singh, serial number
Ajay
35.
Kumar Singh.
Serial number 35.
Okay, serial number?
35.
Serial number 35.
Ajay Kumar Singh, conductor. Place of posting Goriahat. My lord, may kindly see the
Date
last
of birth is 8 September to
date of joining. That is date of joining.
no, date of birth.
No. My lord, may kindly see date of, yes, date of birth.
Date of birth 8 September 1965.
65. It will be 1967. All documents I will show to your lordship, their own documents.
Okay, so if date of birth is not changed, you are going to retire in the month of September, 30th September 2025.
That is the whole difficulty, my lord. If the matter is been
At least so you do it, take permission from your senior so that you can assist the court in respect of item number 8 at least.
Well, beyond reasonable doubt, I will show to your lordship beyond reasonable doubt.
He is going, unless his date of birth is rectified,
I will prematurely
or the issue is not resolved. So he will retire in the month of September. We are in July.
Very difficult.
We are in July. So you take permission from your senior. I tell sir, আপনি ইয়ে করুন তো ওই 9
But so far as 9, 10, 11 is
আমি
concerned.
8 so 8 do it on 24th July. You do it. The court desire that you will assist. Okay. So 8 based on the pair made on behalf of the respondent, the matter stand adjourned to 24th July. আর বাকিগুলো করে দিন। 4 weeks বলছে। And the next can be adjourned to 31st July. Possible.
But this is the identical matter of serial number 1.
4 weeks time.
Identical matter to serial number 1. Your lordship has passed this judgment. Only the name of the petitioner is different. Same notification, same everything, same order can be passed. I will show to your lordship, my lord. Identical matter, only the petitioner.
Identical matter, you give a copy of that.
Yes, my lord.
Same matter.
I have the copy with me, my lord.
Your senior name Debolina Chottoraj?
Yes, my lordship.
But even if Miss Debolina Chottoraj would have been, but it would have been there cannot be any diversified argument to that. She has argued, your lordship has passed order, same notification, identical position.
Fee, what about the fee of